matter, yesterday's SIR matter, there is a date correction. A candidate's appeal has to be disposed of before 9th because there is a second phase last date. Instead, it's come as 13th.
Just a minute. Yesterday's order.
Yes. Para 10. Yes, please. Para 10 minutes.
Para 10.
Yes, minutes. The penultimate page, last but one. To take up that appeal,
On being orally mentioned, the matters to come in board. There is a graphical error in character of yesterday's order. Since the order shall, upon correction, the order shall be read as follows. Additionally, we are informed that the applicant stroke his family members in IN person have already filed an appeal before the appeal tribunal against the exclusion of their names from the order list. If that is the case, we request the appeal tribunal to make an endeavor to decide the appeal, that appeal before 9th April 2020.
yes.
When Sri Sabarimala Case and Senior Counsel for the Coordination of CI assures that necessary supervisory to get agreement on or before the scheduled date.
My Lord, I'm on behalf of the original writ petitioner, my Lord, Indian Young Lawyers Association. My Lord, before my learned brother, my Lord, on behalf of the review petitioner argues, as per your Lordship's order, first the review petitioner would argue. I've got no problem like that. But there is a small little history of this case because it is 20 years old case. It was filed in 2006.
No, whosoever will open,
Giving history as well.
whosoever will open the
I would
case,
feel.
they will give the history also.
Yes, yes, I will present the case, my lord, not taking sides. These
Well,
are
that's
ultimately
correct.
questions of law referred.
My Lord, this case, although these 7 issues have been referred to this honorable bench.
Please take your seat. Now, first of all, before you start anything, come to our order of 16th February. Because that's the most important thing for us.
Yes, my lord, I can, my lord, understand, my lord.
Now, if you kindly come to Para 2, we have simply reproduced the questions of law which were earlier formed. That's not, there is no change in the questions of law.
Yes, my lord.
Now, then you please come to paragraph 8. First, we would like to ensure and just reconfirm from para 4 and 5 that Saraswati Pari is where the counsel. Has she done the compilation completely? Or we can understand you are lost somewhere. Anyway, you have done your job. Very good, very good. And Mr. Krishna Kumar Singh? From your side also, please. All right. Now, please come to Mr. Mehta, Mr. Vaidnatha, Mr. Daman is today, Mr. Gopal is here. All
We
two side
know, my
Gopals
lord,
are
where
there.
your lordships are taking us, my lord.
Madam Indra is there, Raju Saab is there, everyone.
Only a minute.
Now, we have said the review petitioners or the parties supporting them will be heard from 7th April 2026 to 9/4/2026. 3 clear working days we have given. The rejoinder submissions, if any, shall be heard on, and then the original writ petitioners.
Yes, sir.
And those supporting them will be heard from 14th to 16th, again 3 days, and rejoinder on 21st April. Now, what we find from the list of those who are representing now review petitioners or the party supporting them, that you are not adhering to this timeline. and that creates problem for us.
May I?
We are not going to grant more than that time if we want, because please see, out of 33, 9 of us are sitting here. There are other matters, very urgent matters which are awaiting, and we have our own difficulties now.
Correct.
And please bear with us. So therefore, we can assure you whatever in written submissions is given, we are going to read each and every word very minutely. But respect this timeline. That is what we are strongly requesting and persuading you. And for this purpose, I can just briefly indicate, because I've got that list.
But if your lordships can give us 2 minutes before that, my lord. My lord, I think we may not have much problem, my lord. Lord, what your lordships are deciding in these in these 7 questions will govern, my lord, the functioning of the nation, Lord, for at least 30, 40 years to come. Lord, we are conscious of the fact that the court will have its own concerns and priorities, my lord, in the matter, my lord, and we very respectfully, my lord, accept that. My lord, considering the consequences and the repercussions which it is likely to have on several issues, my lord, but we will also not like, my lord, your lordships to be troubled beyond what is legitimately, my lord, required to be placed. My lord, we have also discussed whatever, my lord, is argued, the next learned counsel
Repetition
will
should
not.
be avoided. Repetition should be avoided.
We'll avoid it.
Arguments can be very
We'll avoid
concise.
it.
Arguments
But
can be very concise.
We'll consciously, deliberately avoid.
I recollect Mr. Dhawan argued the Article 370 matter. So the side, all of them were very precise to the point, and
Exactly. My lord, so therefore, my lord, we would also maintain that discipline, whether we will be able to, my lord, adhere
our
to the
intention
timeline or
is not to curtail the arguments. Our intention is
Lordship
not to
would never
curtail the
do
arguments.
that.
Our intention is only, please, there should not be any repetition, and to the extent you can directly come to the point and explain.
We'll modulate in such a way that we don't repeat it.
All
It
right.
will not fair.
I have
because
requested
the-
for a longer time for the reason that the first person may have to read all, my lord, relevant judgments from Sirur Mutt till Adi Shiva.
Yes,
So that will have to be present.
if the first one read out those judgments, then others need not.
Perhaps not.
Others can only simply repeat.
The others will only refer, my lord, to the paragraphs, relevant paragraphs. We will not repeat it. But, my lord, to make our submissions, we may have to refer to them, my lord. For example, my lord, see, just a moment, sir.
You can keep the relevant lines on your piece of paper.
We'll have that. We are having that.
And you need not to force us to open the paper book. And
No.
This creates problem.
That's
When you
correct.
come then please come to page number 1400, 7,000
Opening
and
the papers.
then creates
No,
problem.
we will not do that. We
We
will
can
not.
assure you we will read those pages.
We will not do.
If we are
We
not
will.
read already. Otherwise, you just keep on referring to, we will note down and read.
That's correct, my lord. That's all what we
In
are.
our written submission, we have extracted.
Lord, what I have done is, only a minute. Lord, what I have done is, my written submissions might be 90 pages because the relevant paragraphs I have extracted so that your lordship may not have to volume 7 and volume
We have
8
seen
point
that.
C, etc.
We have seen that part. Some of the paragraphs are reproduced. That's why we are saying, please don't force us to go to volume number so and so, SEC so and so.
No, we will not.
Number
We
We have extracted.
That will create problem.
Your lordships.
Yes, Mr. Dev.
What your lordship says about precision is certainly something all advocates should do at all times. When I have practiced the law abroad, we get up and say we have 5 points to make. I will argue these 3, somebody else will argue 2.
Exactly.
That is the way to do it. As far as referring to things are concerned, we have put the relevant paragraphs in our submissions themselves.
Precisely.
Not surely be entitled to.
To what the learned solicitor has said. My lord, your lordships will be rewriting or rather re-examining Article 25 and Article 26. Now, I have no doubt your lordships will read every word. But if your lordship is satisfied that your lordship wants to hear more, then kindly bear that in mind.
Certainly.
That's all I want to say, because this subject is one of immense importance.
Dr. Rajiv, then you are absolutely right. If we get up from here and we are not sure about that, what we have really understood from both the entire perspective, then probably we will be also lacking in forming an opinion.
I have argued before several benches.
Lord, one fact.
Argued in February that it would end in March. It actually ended in September because of the issues involved.
It will not,
One factor.
It will not be as bad as that.
Very, very relevant.
it will not be as bad as that. Will not see.
Lord, may I just make a single
may be
comment?
kept in mind, which would, my lord, curtail the time also. Your lordships have been very clear in the reference and your lordship's order, which my lords just now were pleased to read, that your lordships would be answering questions referred. So individual facts, etc., are not to be gone into. Some of us, my lord, have also gone into issues like personal law, Appu Mali, Narsu Appa Mali, etc., which is not even remotely concerned. Some of us have gone into right of educational institutions, minority. We are concerned with 25, 26, and what should be the scope of judicial review in interpreting
Beyond
religious.
25, maybe beyond 25, 26, there are some other provisions also referred to like Justice Censud has relied
For
There are 14,
15, yes.
reference to Article 13 also.
Some judgments have referred to Article 17.
Lord,
Lord, either to say that affirming something or to say that it is irrelevant, we may have to refer to something.
This I need only half a minute from you. I try to that broadly categorize because that might help you and it will help us also. One will be one category of the lawyers will be arguing will be broad discretion given to the court to enter into any domain of fundamental right that has been encapsulated into the Constitution of India. That is one broad category of lawyers. Second, court has no such discretion in religious matters, even if it pertains to constitutional morality. That will be one group of the lawyers will be arguing. The third will be the discretion accorded to the court to interfere into religious practices is narrow, but some minorities may be insulated. That is also, we could see that argument coming
which is
forth.
not the subject, question frame.
And one group appears to be arguing that the court may interfere, but only on a case-to-case basis.
Very good.
That is where the facts are being referred to, relied upon. Now, if this is the kind of broad category, then one set of lawyers who want to argue, say, on point one, they can argue one after the other, because that will give a better understanding. That is the only request that is for among you that.
But then there's one problem with regard to that, my lord. There could be overlapping.
That
There
will
could be overlapping, my lord. Therefore, we would humbly request that your lordships may hear us one after the other.
It will create troubles.
And therefore, my lord, when
Compartmentalization will there be.
issue.
One thing, my lord, there is a point in Article 26 that needs elaboration. The concept of a denomination.
We are not on merits. Let me start on merits.
Solicitor. Now, the point here is that is strictly speaking not in the points of reference.
Yes, yes.
It is there, very much.
For your lordships. Because, my lord, in Sabarimala, that's precisely what happened. If denomination is very narrowly defined, a large number of institutions will just go out of the lordship's
Dr.
purview.
Dhawan, question number 3 will take care of it.
Yes.
3 is
It
there.
is there, it is.
Number 3 is very much there.
To highlight in the beginning, because this is something that your lordship might take under consideration.
Question number
My lord.
2 and 3 probably
Yes, sir.
will take care.
They cover,
It
they cover
does
that.
cover it.
My lord,
So we can start now.
Whether-
Yes.
my lord.
Dr. Radhakrishnan, you have a very loud voice. What happened to it? We can't hear you. You need a.
My lord, if your lordship could just give one clarity, I'm in respectful agreement with everything that's been said by this court.
Friends, this is with respect to the list prepared by the Nodal
This is
Council.
a long list, he is on this side. That's
Yes,
what-
yes, that's what, and I may be allotted appropriate time
No,
and
no, it doesn't matter. Don't go by that. That's a ministerial exercise. So it's not that. Don't go by that.
yes. I want to
Our
point
ar-
out that aspect.
While arguing this side, you can support them. While arguing from this side, you can support them. For us, there is a
No, my lord. No, my lord, I am the first,
I may have to give rejoinder.
my lord, I moved the review petition. I was the first. My lords, I was the first person to move the review petition. My lords, I was the first person to move the review petition. My lord, at least give me some time at the end of the hearing, at least.
yes, yes.
My lord, may I just,
So, my lord, now all juniors have become seniors. my name is not included. Give me as a 10 minutes at the end of the board. If it is given at the beginning, I'll be greatly obliged.
My lord, may I just seek a clarification? My lord, I do respectfully agree with everything this court has said and we'll abide by that discipline. There is only one clarification we would like. My lord, the review petitions will not be heard. That is my understanding. Because if we have to address you on the review petitions, my lord, my first submission will be review doesn't lie. But my understanding is your lordship will not get into those issues. And only decides the questions of law. Therefore, the review petitions will be decided later.
Absolutely right.
Your lordships are not deciding.
There will be no mandamus on the earlier judgment of this court, which is in full force and effect. That judgment has not been stayed. So we are happy to address you on questions of law, my lord, which have been framed without interfering with any judgment of this court already delivered. Is my understanding correct, my lord? Your lordship will send the review petitions for hearing to another bench.
The fate of review petition on merits will depend upon how the 9 questions.
That's correct,
are
my lord. That's what your
The
lordship.
judgment is one rendered per incuriam, sub silentio, void, without hearing the people of this country. Presinter alios acta, altori, nosori, non debet.
Because, my lord, each
Presinter alios acta, altori, nosori, non debet. This judgment was rendered behind the back of these people. And this has resulted in this waste of so much of court's time. My ordinary petitions are dismissed in 93 seconds.
Stop him, Malas, but anyway, your lordship, my suggestion is only this. There are some principal parties, like the Travancore, there was some board, like me, the Tantri here. And of course, central government comes first, that's with Mehta. Your lordship on each of the 9 questions may hear them first, because those are the principally affected parties. Hear the interveners later,
Correct.
the various other people who are coming later. I had the privilege of opening Malas, the original Sabarimala and the review before Justice Gogoi's bench. But Malas, let the central government open first, then Malas, we'll sort out between the
Yes, yes. Exactly.
My lords,
We are trying to sort it out in such a way.
my lords,
Yes, I think your lordship.
one suggestion, my lords.
Start. Otherwise,
One. My lords, there is a. May I suggest this?
Submission.
It is not the Sabarimala review, as your lordship has just now clarified. If your
Can I just come to the
lordship
front?
in that this is a reference in Articles 25, 26, that would solve a lot of which I anticipate in the future. It should be seen as one institution lost. We are not looking at that. We are looking at it purely as a question of law. And it will also help, my lords, later when there is reporting.
I think all of us have this broad understanding.
Yes, my lord,
It
if it's formally renamed,
we
in
can-
Articles 25, 26, that would help.
We'll consider that aspect also.
My lord, I have a.
May arise, please keep this in mind.
If that will arise, we will hear it.
When that arises, you argue that. When deciding Articles 25, 26, perforce, the Sabarimala judgment will be looked at.
my lord,
No.
my lord, I have got to say on that.
That Sabarimala judgment will be looked at.
All the judgments
Saying that can be divorced completely may not be correct.
No, my lord, that will take you to the review.
Not on the merits of the review. Right? Your lordship will have to look into the judgment.
My lord, may I submit one thing, my lord?
on the questions of law, it will be looked at, not on the review.
The whole exercise is of enormous waste of public time, judicial time. So much of cases could have been held by this.
My lord, could I make a mention? Apart from all this, this thing is a different matter.
Our understanding, I think I agree with Ms. Jaising.
My lord.
An organization.
Normally, you are being criticized for what you're saying.
I said, my lord, I would be happy if the PAL business is coming to an end. People come without see, PAL means you come, my lord, none of my rights are infringed.
Nadumpra, your answer can be, my lord, wait for some time, I will keep my own original color.
No, my lord, I am waiting for the end of the board. If your lordship will hear me for 10 minutes, then the bench can be discharged in 1 hour.
Itself has taken longer than 10 minutes. My lord,
They are all against me. They are all against the all designated lawyers are against me. 99% of the ordinary lawyers support
Let me
me.
start, my lord. Let me start.
my lord, before my friend can start, my lord, there is a, my friend.
Time be set apart for interveners, especially those representing multiple different religions. And
What will happen? You have given the timelines from your side. I have also done in consultation my sister and brother some homework on that. Let us see that how it proceeds. Then accordingly we will keep on requesting you.
My lord, I have an urgent mentioning which has got nothing to do with all this.
Oh,
If your lordship, this is a matter which requires serious concern. There is a rape and murder of a 4-year-old child in PS Ghaziabad. Interestingly, though the postmortem shows aggravated assault, sexual assault, there is no investigation which is directed towards rape. Only an FIR in relation to 302, that too after great persuasion, has been registered. This requires consideration, my lord.
who is the petitioner?
The
parent?
petitioner happens to be the father. The father.
No, who is this?
The father of the child. The father of the child is the
Father.
petitioner. This way things go on, my lord. No child is safe.
You want to be listed tomorrow? You want to be listed on
Yes, my
Friday?
lord, tomorrow. Tomorrow, day after, whenever your lordship thinks it's appropriate, but it needs urgent hearing.
You will give you choice if you want tomorrow or on Friday.
What is the prayer?
Friday.
What is the prayer? Listen to me. What is the prayer?
I am seeking transfer of investigations, my lord. There is no investigation which has happened.
That we will consider on merits. Once
Yes.
we list the matter.
Your lordship will have to hear me on merits. I will show to you how things are going on.
We'll have to hear you and then only pass.
Yes, yes, yes. Friday, my lord.
Right.
Very well.
Mr. Hariharan, tell your junior to make sure that if defects, if any, that is cured.
It will be cured.
Even if there is, we are listing it on.
Very well. I'm sorry to hold you all up, my lord.
My lord, please have a look at, my lord, my volume, my lord. This is thicker because extractions are there, but your lord did not have to go through the judgments.
They are using electronic copies.
No, I'm on this. You're sitting there, I need you there. So if you can sit there, if you don't. So nice officer, you.
right.
Lord, please come to page 1. Lord, there is something important, my lord, which makes our job a little more responsible, my lord. Lord, your lordships have page 1. Lord, why this is important and why our job is more responsible. It's not, my lord, one particular aspect centric matter. My lord, please, when the court was, my lord, court has referred the matter to 9 honorable judges. It was, my lord, incidentally authored by Justice Gogoi. Justice Gogoi is the author in Adi Shiva judgment. I'll come to that, my lord, that need not be written. But Adi Shiva judgment takes note of law from Sirurmat till that date, and thereafter when this order is passed, the judgment in Sabarimala was also there. Now, keeping that in mind, please have a look, my lord, why we are before your lordships, my lord, and what is, my lord, the scope of this reference. Para 4. It is time that this court should evolve a judicial policy. It's not, my lord, one judgment being right or one judgment being wrong or one practice, etc. Judicial policy befitting to its plenary powers to do substantial and complete justice and for an authoritative enunciation of the constitutional principles by a larger bench of not less than 7 judges. My lord, why 7 honorable judges? Shirur Math is 7 judge. The decision of a larger bench would put at rest recurring issues touching upon the rights flowing from Article 25 and 26 of the Constitution of India. It is essential to adhere to judicial discipline and propriety, and more than one, my lord, I am not going into it. Only purpose, my lord, is एक chair ले दो, ये रखो. There is a chair.
Fine, Prasad.
There is a chair.
But give one chair.
No,
please.
there is a chair. I was hinting, my lord,
That
only.
one chair give to Mr. Devan.
String on. Fine, carry on.
There is a chair there. Yes, yes. Yes. Now, my lord, your lordships will have to adjudicate and interpret broadly three terms so far as religion is concerned. Article 25(1), I'll come to that, the text uses the word religion. Second term which is used is Article 25(2), which uses the term religious practices. And Article 26, subarticle B, uses the word to manage affairs relating to religion. Lord, what has happened is, there are, Lord, three things which in my submission has happened, and central government is not taking, my lord, one extreme view or the other. I am assisting your lordships what can be the possible way of answering questions and what can be the contours of your lordship's judicial review, which is one of the questions framed. Lord, neither in Sirur Mutt till Lord Sabarimala judgment, Lord, that's the journey of Article 25 and 26. Well, Lord, three things are not noticed. A, the Constituent Assembly debates which brought 25 and 26 into existence. B, Lord, the enormity and width of religions in this country. My lord, we are not dealing with, my lord, one religion. The country is having, my lord, a very proud plurality of religions, Hindus, Muslims, Christians, and other, my lord, Judaism, etc. But the beautiful part is, there is internal plurality in the religions also. Hindu has several sub-denominations. Philosophically, my lord, Hinduism is a way of life. But for constitutional purposes, it is a religion. It is also a denomination. But it is also divided in several denominations. And each denomination has their own independent denomination, which are ultimately referable to the broader concept of Hinduism. Lord, that is, my lord, possibly not presented so far. Same is about, my lord, the Islam. Now, whatever I have studied about the Islam, my lord, the only difference is that it has one particular holy book where you take guidance from, and one particular originator. My lord, that is Honorable Prophet Muhammad, which is the distinguishing feature. But even in Islam, there is an internal plurality. It's not all Muslims, my lord, which are, my lord, as a one class, one denomination. There are several denominations. When we, my lord, your lordships will have to examine and answer what is denomination. And the same, we have Shias, we have,
They are occupying chairs.
one young lawyer I requested, but he declined. But anyway, you need not.
Lordship, always the SGs are respected SGs are having me problem. I am in the second line.
I said some seniors are standing.
I am always left my seat, sir. And
All right, sir. Yeah, only. But my answer would be a dignified silence. I requested when Mr.
Not only to you, to everyone.
Sundaresh was standing, I requested him that please give a chair, a very senior member. Anyway, my lord, leave it at that. The only answer sometimes is the dignified silence. Lord, now, similar is, my lord, Shia Muslims, Sunni Muslims, sub-denominations, etc. And this, my lord, broadly, your lordships are not examining, my lord, theological part of the religion, but must remain in your lordship's mind that Hindu religion is not just Hindus, Islam is not just Islam, Islam has denominations, Christianity has denominations, and this is the beauty of not only pluralistic society in India, but internal plurality, which coexist within the religion also. My lord, just taking 5 minutes of your lordships, my lord, this is what, my lord, your lordships may bear in mind, my lord, while deciding the word religion, religious affairs, and matters pertaining to religion. My lord, there is a reason why religious affairs words are used. Earlier, my lord, it was only religion. But I'll come to that. My lord, there is a purpose. For example, during the Constituent Assembly debates, it was only matter pertaining to religion. But one of the honorable members said that some matters are not pertaining to religion, but they are religious practices. And he gave an example of Ganpati Visarjan, that it is a part of Hinduism, broader doctrine. But Ganpatya Sampradaya is a separate denomination. It is not, it may not be a part of Ganpatya Sampradaya, but it is a practice followed since at least 300, 400 years. Lord, kindly have a look at Lord, this chart. I will not take more than 5-7 minutes on this point, and I'll switch over to the main points. Lord, this is the width of the term religion, which would, my lord, be a guiding factor for your lordships to decide to what extent, whether a Hindu denomination is before your lordships, or a Muslim denomination is before your lordships, or a Christian or any other religion, to what extent your lordships would have the expertise on the subject, and to what level we will be able to assist your lordships, my lord. That is an inherent limitation, my lord, which is subject-specific limitation. Please have a look, my lord. This is, I have given, my lord, for Hindu religion. I have also given, my lord, for other religious, my lord, religions. My lord, as we call Sanatana, my lord, that is Hinduism, we have 4 Vedas. Your lordships are aware: Rigved, Samved, Yajurved, and Atharva Ved. It prescribes several things, my lord. Then we have 4 Upvedas, that is Dhanurveda, Gandharva Veda, Ayurveda, and Arthashastra. Arthashastra may deal with only economic aspects, my lord, perhaps. Then we have 6 Vedangas. My lord, this is to preserve and follow the Vedas, which are Shiksha, Vyakaran, Chandas, Niruktas, Jyotisha, and Kalpa. Now we have 4 Upangas. My lord, one is Dharma Shastra. My lord, Yagnavalkya and Parashar, my lord, immediately came to my mind, my lord. But Patanjali also can be, my lord, added in this category as per my limited understanding. Then we have Puranas. We have 18 Mahapuranas, 18 Up-Puranas, Ramayana, and Mahabharata. Then we have Mimamsa and Nyaya Shastras. Now please turn the page over. It goes further. Mimamsa and Nyaya Shastra, my lord, which ultimately finds its roots in Vedas, my lord, has 6 components, and these are recognized components. My lord, Nyaya, Vaishalika, Sankhya, Yoga, Purva Mimamsa, and Uttar Mimamsa. Correct, my lord? Kindly mark, my lord, what I have said. This is Astik Darshan. My lord, because there is one beauty in this religion. You can be Nastik. You can be a non-believer. You can be an atheist. You can be an agnostic and still be a Hindu. I'll come to that, my lord, for 2 minutes only. Now, my lord, we have Uttar Mimamsa mein Upanishads, Bhagavad Sutra, and Bhagavad Gita. Now, Agamas. My lord, Agamas are the only things which are referred to by Justice Mukherjee, my lord, my lord, Justice Venkataswamy in Devaru. My lord, above that, nothing is, my lord, discussed. Therefore, my lord, I am pointing this out. My lord, 6 Agamas. We have Shakta, Shakti Sampradaya, my lord, those who believe in Shakti. We have Shaivites. We have Vaishnavites. Then Ganpatya Sampradaya. The Lord Ganesh, Vignaharta, is the deity, is the Ishtadev. Then Kumara, that is Kartik Swami or Lord Murugan. Or Saurya, that is Swami, my lord, it should not be Swami Narayan, it's a typo. It should be Surya Narayan, my lord, it's sun god. It's a, my lord, autocorrect mistake. Kindly correct it, my lord. It is Surya Narayan.
That's between the two.
Yeah, yes, your ladyship is absolutely right, my lord. And last, and according to me, my personal belief, one of the most beautiful part of this is Nastik Darshans. Nastik means non-believer. They don't believe in God. They don't believe in existence of any superpower. And my lord, when I was studying this, long back, not for this matter, I was really surprised and I felt proud that Charvak Darshan is dating, my lord, few thousand years, where the world did not have the concept of religion. And Charvak Darshan, in those days, is the first atheist of the world. He did not believe in God. He did not believe in any superpower. He said there is no destiny, there is no person or a body or a power or anything which controls your destiny. The moment, the way a tree exists, a human exists. The tree is destroyed, the human is dead. Nothing happens, no karma, no afterlife, nothing. And there was his following. Charvak had his own following. Charvak Sanhita is still followed by several. Then second is Jaina Darshan. Jain Darshan and Buddha Darshan also, they do not believe in God. Both Jainism and Buddhism, they do not believe in God. They do not believe in afterlife. I'm not, my lord, giving a theological, my lord, background, but this would be necessary. Now, my lord, please have a look at.
Just Mr. Tushar, if you say the Jain and the Buddhists don't believe in afterlife, then where the Tirthankars one after the other reincarnate? There is a belief.
No, Gnostics don't believe one after the other.
No, Jain and Buddhism, you say. You say they don't believe God, but it ends with the death. That's sudden. But there are Tirthankars in Jains, it says that they are reincarnation.
Well, Lord, that is exactly the difficulty, because neither I am competent nor your lordships would be able to know. In Buddhism, what they believe is salvation, moksha, that you are dead, you are liberated. There is no afterlife. That's what I say. There is no afterlife. They don't believe in idol worship.
Probably Charvak here, my brother is giving that example, Rutampi went, but he will share
We
that.
identify pursuit of happiness to John Locke, but it actually relates to Charvak, where Charvak says, Jitam jivat, sukham jivet, rinam kritak, kritam pibat.
Yes, but very popular.
So long as I live with material happiness. Even I will be in debt.
I'll consume ghee.
The material happiness. Yes. So pursuit of happiness in the American Constitution, in fact, relates to Charvak.
Much. He says whatever is there is in this world. These are all material things you enjoy.
Yes.
Your lordships are right. Yes. Even if you have to incur debt, you incur debt, but consume ghee. Ghee means consume all which is
material pleasure.
Material pleasure.
So I will go into debt, which spiritually is impure, to achieve the material pleasures of existence.
Material life. Yes.
So it's an existential theology.
Yes.
And we do not require John Locke to remind us.
To mind, yes.
This is Charvaka.
It is the Charvak, my lord, some few thousand years back. My lord, answering my lord's question, so they do not believe in afterlife means, my lord, some denominations of Hindu believe that this is only a body. What is the soul is eternal and it only changes the body. From one body, it goes to another body. In Buddhism, there is a concept of nirvana. Nirvana or mahanirvana means once you're dead, you achieve salvation. You literally achieve liberation. You don't reborn. You are not reborn. You don't get a rebirth. That is the concept I'm saying. But that is a non-idol worship, my lord. Lord, I just, my lord, hurriedly conclude this. Thereafter, my lord, comes, my lord, one of the most visionary, my lord, saint who, my lord, walked on this earth. That is, my lord, Adi Shankara, Shankaracharya. Taking into consideration all this, my lord, denominations and non-denominations, he codified Hinduism, or Sanatana as we call, in 10 different sections, which is called Dashanam. Dash means 10, Nam means names. And my lord, what is Dashanam? One is, for example, I'll just give one example, Tirth. Lord, Tirth is one section of that Dashanam. They would have a separate name. If I become a Dikshit in Dashanam Sampradaya with Tirth, then my name would be so-and-so Tirth. You can find out from the name of the saint that he belongs to Giri Sampradaya, Tirth Sampradaya, Bharti Sampradaya, etc., etc. Everyone would have a different tilak. So you identify that he belongs to Dashanam and this particular category. Everyone would have a different salutation for each other. The moment he says Alakh Niranjan, you find out which one of the categories is belong to. But these are 9 categories. 10th category is in what our legal parlance we say residuary entry. Those who do not fall or do not wish to fall in 1 to 9 would be Hindus under the 10th category. It includes non-believers. It includes those who believe in books, for example, Sikhism. Those who do not believe in idol worship, and those who do not believe in anything. So I can be a non-believer, non-idol worshipper, and I believe in Charvak theory, but I can still be a Hindu. Lord, this is the broadness of any religion. Lord, your lordships will have to keep in mind. Lord, immediately, my lord, I'm not, my lord, getting into beyond a point, my lord, but please have a look at, my lord. This is the, same thing with, my lord, Islam, my lord, that is, and, my lord, the main 5 elements are saying, my lord, zakat, etc. My lords would be aware. The holy book is Quran, and Prophet Muhammad is the last prophet, my lord. And, my lord, but based upon the doctrinal differences, my lord, page 155, I have given, as per my understanding, these are the denominations which are within one denomination called Islam. But they are all Islam denominations. 155, my lord.
This compiling.
PDF 158, my lord, if your lordships are having PDF 158. I'm not, my lord, taking your lordships through this in detail, but Islam, the holy book Quran, then Sunni, Shia, and Khawarij. My lord, Khawarij is now not, my lord, much
stable.
Yes. But your lordships need not go in detail into this. My purpose of showing is that let us not take Hinduism, Islam, or Christianity as one particular broad denomination and then take decisions whether it would be a religious practice, whether it is a religion, whether these are affairs pertaining to religion. And therefore, my lord, in section 26B, the framers of the constitution, my apologies, I'm not a constitutional lawyer. Article 26B, they have specifically added not only religious affair, any section thereof. So I need, my lord, I'll give you the broadly, my lord, the why section thereof. Kindly have a look at, my lord, the constitution. And there is a purpose and, my lord, a vision of the visionary constitutional framers, my lord. Why as the word section thereof is used. 26, the first part, my lord. Subject to public order,
Where are you referring?
so I'm reading Article 26, my lord. And I'll give the reason, my lord, why our constitutional framers were visionaries and why this expression was specifically added subsequently. Freedom to manage religious affairs. Subject to public order, morality and health, every religious denomination or any section thereof. Well, what is the purpose? I'll come to that, my lord, in a detail little later. What is the purpose? My lord, suppose, take for example, my lord, Shirdi. Hindus go, Muslims go, all denominations of Hindus go, Shaivites go, Shakti Sampradaya goes, everyone goes. So it is not confined to one particular denomination. It is section of denomination. Well, for example, Tirupati Balaji. One can say it is a Vaishnavite shrine. One can say it is not a Vaishnavite shrine. It is a Hindu shrine. As Sabarimala says that all are Hindus, all who go are Hindus. So we cannot recognize any denomination. My lord, I'm not arguing that, but Sabarimala does not even consider or refer to the word section thereof. That's a matter of argument at the time of, my lord, review. So, my lord, section thereof, my lord, for example, Khwaja Moinuddin Chishti Dargah. Hindus go, all communities go. which denomination you will, we will put it, my lord, if there is some question arises. It would be a denomination because it is a part of section of one larger denomination. Khwaja Nizamuddin Aulia. Everyone goes. So there are, my lord, reasons and reasons, my lord, why we cannot blindly and reverentially adopt American doctrines or foreign doctrines, because our religious structure is differently plural, and internal plurality, which gives beauty to it, my lord, has a totally different dimension. And therefore, we did not lift the religious freedom either from the First Amendment of American Constitution or any other constitution. Our framers, though they have adopted some provision in some other articles, 25 and 26 are designed to suit Indian condition.
But Mr. Solicitor, 25, 26 is an import from the Constitution of
Ireland, yes.
Article 44.
Yes, my lord. But, my lord, it is made or tailored in peculiar Indian situations. It's not word by word thing. That's what, my lord, Dr. Ambedkar also says, that it is derived from in Constitution of which is Ireland. But Ireland was a theology.
That history of being uniquely Catholic in a Protestant monarch.
Yes.
Or an Anglican monarch.
An Anglican, which, my lord, they used to oppose, and there was rebellions and revolts and etc., etc. So, my lord, and similar, my lord, Christianity, I'm not, my lord, going into it because this is not what your lordships would be essential. My lord, Buddhism also, my lord, please come to page 160, which is, my lord, the PDF page 160, my lord, 3. I just want your lordships to see the chart that Buddhism is not, my lord, one denomination. That's the, my lord, possibly our lack of assistance, that in all earlier judgments, we never, my lord, pointed out that this is the internal plurality within one religion. So your lordship's view also will have to be, my lord, suitably examined. My lord, Buddha's teachings, that starts, my lord, then oral traditions, 18 schools were developed. First notion of Mahayana Buddhism, my lord, etc., etc. My lord, Chinese Buddhism is different. Then Vajrayana Buddhism, my lord, which traveled from India, my lord, which is now being practiced, essentially Mahayana and Vajrayana in Bhutan, Ladakh, Sikkim, etc. My lord, that's not the purest form of Buddhism as Lord Buddha preached. It has, my lord, some element of Matara.
Tantricism.
Yes.
It's a hybrid between Tantricism
and Buddhism. It is, my lord, Shaiva Tantrism. The Muni Padma Sambhava in 8th century made a fusion of Buddhism and Shaiva Tantrism, and that is the form of Buddhism which is, my lord, in vogue in Tibet, Bhutan, Sikkim, and other, my lord, areas. So there is an internal plurality, my lord. That's all I'm trying to, my lord. Then Vajrayana also, my lord, which has, my lord, next page, my lord, I have given several branches. And, my lord, Christianity, with whatever limited, my lord, understanding I could gather, my lord, because these are general things, my lord, and I have done my own research only to show it is not one thing to say I am dealing with Christianity as a religion. Your lordships will have to decide several things, and the question would be, would the court have the necessary expertise to go into those questions? Your lordships may bear in mind, in most of the cases which we cite for the findings recorded or the ratio, but all those cases came from civil suits. Whether, most of them, whether religious practices, it is a long religion practice, etc., etc. So, my lord, this is early Christian church, Eastern Orthodoxy, Roman Catholicism, Protestantism, and, my lord, there are some, my lord, denominations within one larger denomination. So, my lord, kindly bear this in mind. My lord, in India also, my lord, at page 170, which is, my lord, at 173, I have given, my lord, Indian Christianity also, my lord, year-wise, how, my lord, they have separate denomination. The doctrinal beliefs are same. And one holy book, my lord, that is Bible, that is common. The founder is common, but doctrinal differences, principled differences, etc., interpretative differences also maybe, my lord, a worldly word, my lord. It's not difference, but another way of looking at the same thing. And that is how, my lord, this plural, internally plural religious practices, my lord, develop. Now, my lord, coming back to the main matter now, please have a look at, my lord, something which, my lord, in my respectful submission, subject to being corrected, is missed. My lord, when we interpret Article 25 and 26, which can never interpreted without looking at the preamble. Your lordships have always interpreted fundamental rights in light of the preamble. My lord, at least the judgments which I could see, and I would place some paragraphs, my lord, this part is not specifically noted. Please have a look at page 5, which would be, my lord, 8, my lord, PDF 8. I'm just, my lord, your lordships have read and reread preamble several times, but in this context, only one right, my lord, what we have given to ourselves. My lord, I have highlighted in red color. Your lordships have in red color, my lord. Liberty of thought, we are not concerned possibly. Expression, it can be 19(1)A expression or expressing religious belief also, because if we go by Egestem generis, expression, belief, faith, and worship. This is what is ensured in the preamble. My lord, your lordships may consider, my lord, requiring Article 25 and 26 be interpreted, keeping in mind the faith and belief also. Because there can be several things which are capable of belief system. It may not be emanating, my lord, as a, this is necessary because of the unnecessary doctrine of essential religious practice being introduced. How do you decide? It's a matter of faith. It's a matter of belief. Whether this is essential or this is not essential, you will have to first examine and make a judicial review of religious scriptures. You will have to understand the religious scripture the way it is meant to be understood, which is impossible, my lord, unless we achieve that level of spiritual supremacy. We will also not be in a position to assist what exactly Prophet Muhammad said, or for that matter, my lord, Lord Jesus said, or my lord, the Veda says, or Upanishad says, other things they will say. And based on that, my lord, there can be a faith and belief system which has developed, which is not otherwise contrary to public order, morality, health. And part 3. Then how would your lordships examine the essentiality of that? So that's the purpose, my lord. Now, my lord, coming to how, my lord, the 25 and 26 was framed. And I will be citing this, my lord, so that it's, I'll have to show the route, my lord, because this was not shown, my lord, earlier to earlier benches, or maybe it has missed or whatever, my lord, I'll not. My lord, the first part is what happened prior to the Constituent Assembly set to debate the draft constitution placed before it. Well, before that also there were proceedings, there were committees, committees on minorities, committees on religious freedoms, etc., my lord. These are, my lord, also this is, my lord, pre-Constituent Assembly debates, deliberations on 25 and 26. I have confined it to 25 and 26. For completeness, I have placed everything, but I have marked, my lord, what is not to be read, because it is irrelevant for the questions to be answered. Now, kindly see at page 10, my lord, PDF 13. This is how, my lord, the first draft was placed by Kanayalal Munshi. No, the 3 comes there, the subsequent.
Was taken up, no, earlier.
Well, please, religious and cultural freedom. No, they are discussing 25 to 30. We are not concerned with anything other than 25 and 26. All citizens are equally entitled to freedom of conscience and to the right freely to profess and practice religion in a manner compatible with public order. I'm sorry, page 10 and page 13, my lord, if it is PDF. Printed page 10.
That's it.
Yes. All citizens are equally entitled to freedom of conscience and the right freely to profess and practice religion in a manner compatible with public order, morality, or health, provided that economic, financial, or political activities associated with religious worship. Please underline this. Religious worship was the word initially, shall not be deemed to be included in the right to profess or practice religion. Your lordships would might, the word propagate is not there. Something turns on that. Therefore, my lord, I am pointing out at this stage. Then, my lord, 2, your lordships can skip. Citizens belonging to national minorities in a state, whether based on religion or language, have equal rights with other citizens in forming, controlling, administering at their own expense, charitable, religious, please mark, this goes ultimately, my lord, in 29 and 30. There cannot be any educational institution of either a linguistic minority or a religious minority, which is educational religious institution. Nothing turns on that for these questions, but I'm just, my lord, pointing out because one of us, my lord, is going to raise possibly the question that 25, 26 applies to educational institutions also. And social institutions, schools and other educational institutions with the free use of their language and practice of their religion. Then no person may be compelled to pay taxes. Well, this becomes Article 27, we are not concerned. Religious instruction shall not be compulsory. This becomes Article 28 in a different format, but we are not concerned. Then no person under the age of 18 shall be free to change his religious persuasion without the permission of his parent or guardian. Conversion from one religion to another brought about by coercion, undue influence, or offering of material inducement is prohibited and is punishable by the law of the union. Please turn the page over, my lord. Then, my lord, Article 2, my lord, there is some. Dr. B.R. Ambedkar independently circulated a memorandum. I have said that. There were 3 drafts, but period, I have said. I'm not as conversant as you, but I have said it subsequently. Yes. Yeah. Continuously, I am overhearing you. Dr. B.R. Ambedkar independently circulated a memorandum and draft article. My lord, his draft article was like this. The state shall guarantee to every Indian citizen liberty of conscience and the free exercise of his religion, including the right to profess, to preach, and to convert within the limits compatible with public order and morality. My lord, this was the draft suggested by Dr. Ambedkar. My lord, now please see, my lord, Rajkumari Amrit Kaur and Dr. Hansa Mehta, my lord, 2 eminent lady members. My lord. India, my lord, has always not only, my lord, treated ladies equally, they have always been treated at a higher pedestal. My lord, there are several judgments of the recent past where, my lord, there is a concept of patriarchal society or my lord, there is some gender stereotypes, etc. They were never there. We are the only generation, arguably, we are the only, my lord, Indian society, we worship ladies. The President of India to the Prime Minister of India to the judges of the Supreme Court, we bow down before our lady deities, my lord. So let us not introduce those concepts of patriarchy and, my lord, gender stereotypes, etc. There has never been. So, my lord, these 2 eminent ladies, Rajkumari Amrit Kaur, my lord, who became the first health minister in Pandit Nehru's cabinet, My lord, they raised
Call them the founding mothers.
founding mothers.
We always say founding fathers.
Yes.
Of the constitution. So let us call these 15 women.
Yes,
the
my lord,
founding
founding
mothers.
mothers of the constitution.
Yes.
Correct, correct, correct. Now, my lord, they had pointed out a correct problem.
Ah, yes. These 15 women.
Yes, yes, yes. It's biographical
No,
narration
participation in the committees,
committee also.
in the assemblies, their contribution and how some of the articles, especially Article 15(3).
And my lord, even 25, 23. My lord, their objection was, apropos your leadership's, my lord, very right and pertinent observation. Their objection was that if you say right of religion, some religion forbids what otherwise our social reformers have prohibited. For example, somebody may say sati pratha is a part of the religion. Somebody may say child marriage is a part of religion. So he said that you will be nullifying all reformist actions which have been successful by way of laws preventing all this. That was, my lord, a very pertinent objection raised by Rajkumari Amrit Kaur. And my lord, she says, article so-and-so of Mr. Munshi's draft was Lord, kindly now turn to page 13. Your PDF page would be 16. My lord, I'm just making a reference. Nothing turns on that for the questions. But Sardar Harnam Singh said that you specifically clarify that right to carry a kirpan is a part of our religion, which was accepted. No, that's what, my lord, I have said. Then 27th of March 47, the subcommittee accepted Munshi's formulation of anti-conversion clause, which was clause 7. My lord, same thing which I read, my lord, was accepted. Then, my lord, 31st of March 47, as I pointed out, Rajkumari Amrit Kaur, on behalf of herself and Mrs. Hansa Mehta, wrote to B.N. Rao, my lord, who prepared the first draft. It was Sir B.N. Rao, my lord, dear lordships are aware. Emphasizing that many oppressive practices, that is child marriage, polygamy, untouchability, are justified in the name of religion. They proposed narrowing the right of freedom of religious worship rather than broader practice of religion. My lord, therefore, my lord, she suggested that we should have not have religion, but some other word may be used so that earlier wrong practices may not come back. Your lordships can skip that. My lord, please come to page 14, next page, my lord. First conjoined draft report of the Subcommittee on Fundamental Rights was published. It contained clause 16 and 23 on religious freedoms, including right to profess and practice religion, subject to order, morality, and health. Kindly mark propagate was not there. It was only practice and profess. Rights of religious denomination to manage affairs and own property, prohibition on compulsory religious taxes, anti-conversion clauses, that is 22 and so and so. My lord, then see, my lord, 16 is what is 25 today. That's the only thing which needs to be seen, my lord, on this page. All persons are equally entitled. Please see, my lord. These words are introduced for the first time. Now, kindly pause here for a moment. Why am I insisting or emphasizing on this? Lord, Sabarimala judgment reads that equally entitled includes gender equality. My submission is going to be on interpretation. Gender equality is already taken care of in Article 14 and 15. They are equally entitled. For them, it need not be repeated. Why they are saying equally entitled? The framers were aware that we are dealing with a pluralistic society. And my lord, there is a discussion that one religion may not claim better rights than the other merely based upon the numerical strength. And your lordships would also bear in mind, my lord, the date is 3rd of April 1947, where, my lord, the partition process had started, communal riots were taking place, and the framers of the constitution were aware about the concern that one religion may, based upon the their numerical strength, might try to get something more than the other religions. And therefore, they added the word equally entitled. It has nothing to do with gender. It has something to do only and only with religious plurality of the country, accepting the situation prevailing on that day. Now, my lord, further.
Equally entitled to freedom of conscience.
Yes. So, my lord, everything, my lord, man and women, both are equally entitled to all fundamental rights, which is taken care of in 14 and 15. You need not repeat it. And therefore, it is not repetition on gender basis. It is introduced as a religious freedom so that one religion may not take or may not understand it to have been given more rights than another religion.
No religion is superior than the other.
Than the other, no religion is subservient. All are equal. It is, my lord, manifestation of secularism. It has nothing to do with gender. All persons are equally entitled to freedom of conscience and the right freely to profess and practice religion subject to public order, morality or health, and to other provisions of this chapter. This also comes for the first time. But propagate word has so far not come. Now see the explanation 2. One is, my lord, regarding Kirpan. My lord, we are not concerned. 2. No person, the right to profess and practice religion shall not include any economic, financial, political, or other secular activities that may be associated with religious worship. So, worship word continues, my lord. Earlier, my lord, what was used was religion. Religious worship, which was objected to by Rajkumari Amrit Kaur and Hansa Mehta, but it continued, which is subsequently changed. I'll come to know.
The word worship is there in the preamble also.
Yes, it is there. It is there, my lord. But in the fundamental rights, the objection was this, that if you say religious worship, some of the reforms which we have made might get nullified, because Constitution was being framed as a stage where there were statutory laws prohibiting sati. Sharda Act was, my lord, against child marriage restraint, etc., my lord. So they would refer to Sharda Act also. Sharda Act is, my lord, the name of the act, my lord, based upon the proponent of that act, my lord. But it was Child Marriage Restraint Act. And their concern was genuine, but which is taken care of, my lord, subsequently. My lord, now please see page, my lord, 17, the PDF 20, 10.4.47. Earlier, your lordships have noticed state's power to make a law for social reform was not there. It was only subject to public order, morality, and health, and other provisions of this part. So it was kind of an unqualified right given. Lord, yes, my lord, 8.4.47. Constitutional advice, my lord, that your lordships can skip 14.4.47. Kindly come to the next date. Aladi Krishna Swami Iyer wrote another letter specifically suggesting a clause empowering the state to enact social welfare legislation as suggested by Rajkumari Amrit Kaur and Mrs. Hansa Mehta. The relevant extract is reproduced here and there. Incidentally, Mrs. Hansa Mehta was the wife of first Chief Minister of independent Gujarat when Gujarat was separated, but she was a leader and an intellectual in her own right. She was there in the Constituent Assembly not because she was wife of Jivraj Mehta. Then, my lord, kindly see the bold part.
She has spoken extensively on
Extensively,
how a governor should perform under the constitution.
Yes, my lord. That is where, my lord, the word constitutional morality came. Constitutional morality is I'll come to that, my lord. It's a separate chapter. It's a political doctrine as to how government, constitutional functionaries, they should behave, function, work. When there is constitutional silence, then there are certain constitutional conventions. And that convention is known as constitutional morality. But subsequently, in the recent years, but constitutional morality left that meaning and became a standard of judicial review, which I'll not come to that, which was never conceived. Constitutional morality means this. It's how the constitutionally functionaries should function. And there is a material available that this is how they understood. Dr. Ambedkar also understood it in that context only. The famous speech which is being cited for constitutional morality. To meet the point and then the suggestion is this. To meet the point, an explanation or proviso to the following effect may be added. My lord, now the suggestion of the Honorable two ladies, my lord, the right to profess and practice religion shall not preclude the legislature from enacting laws of social betterment and of the people. My lord, the wordings change, the spirit, my lord, continued thereafter. My lord, now it is something else. That becomes, my lord, Article 25 to 2, B particularly. Then your lordships may come to, my lord, next page, 16,447. Now, I'm skipping everything which is not relevant, my lord, for your lordship's consideration. And therefore, my lord, I'm trying to meet with the report issued with revised clauses on religious freedoms. Clause 16 now guaranteed freedom of conscience, freedom of religious worship, and freedom to profess religion, with a significant narrowing from the earlier practice. Clause 17 to 22 addressed denominational rights, religious taxes, etc., etc., my lord. Now, my lord, it becomes religious worship, my lord. Correct, my lords? I'm not reading it, my lord. It's only a transient provision which ultimately, my lord, went into some changes. Please come to page 19, my lord, PDF page 22. Lord, this is only, my lord, to complete this. Lord, there were discussions that conversion should be permitted as a fundamental right. And therefore, the word propagate should be added. This is what, my lord, it says. Subcommittee of minorities was formed with Dr. H.C. Mukherjee as the chairman. Mr. Ruthnaswamy pointed out that Christianity and Islam are essentially proselytizing religions, and the clauses should permit them to propagate them. Proselytizing means having the idea of converting people. That was one individual view, before the committee. Dr. S.V. Mukherjee noted that the right to build places, we are not concerned, my lord. And then your lordship can, my lord, kindly come to next page, 18,447. Now, my lord, there is a change. The word propagate is introduced in the draft. All persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion subject to public order, morality, or health, and to other provisions of this chapter. And that explanation to the words religious worship, religious practice should be substituted. Then, my lord, rest may not be relevant, my lord. On the bottom is, my lord, recommendation for anti-conversion, etc. My lord, now come to the next page, 21, Lord, PDF page 23. The clauses went for discussion and debate before a larger advisory committee to discussion. The discussion accepted the change or to explanation 2 from religious worship to religious practice. Lord, therefore, my lord, the suggestions were again accepted. Chairman Sardar Patel requested Sri Rajgopalachari and Sri S.P. Mukherjee to draft a comprehensive clause allowing the legislature to intervene to reform and regulate secular affairs. Only secular affairs. Their proposal was appending a new explanation stating that nothing in this right to practice religion shall debar the state from enabling laws for the purpose of social welfare and reform, and was swiftly approved. That any religion, the state can make a law for the purpose of reform or social welfare. This was approved, my lord. The word propagate was taken up at the instance of Ruthna Swami. Munshi and Iyer noted it was already covered by free speech guarantee, but G.V. Pant intervened and said, at worst, it is redundant and it may not harm anyone to adopt it. The word was thus included. Then clause 17, several members including Sardar Patel, Ambedkar, Munshi and Rajgopalachari debated whether legislature ought to be allowed to prohibit religious bodies from holding property. Rajgopalachari offered a middle path, retaining the clause but qualifying it with subject to general law. This becomes 26D in a different format, but the same thing, right to own and administer property, but not an unqualified right as per the law. So the state can make the law. The debate of anti-conversion clause 21 and 22 between Sri S.P. Mukherjee, Bakshi Tekchand, Frank Anthony and Ruthna Swami was settled by Sardar Patel's observation that forced and fraudulent conversion was already an offence under existing statutory law, and the matter was better left to the legislature. My lord, then, please see, my lord, next page, K.M. Munshi. My lord, the rest may not assist your lordships on these questions. There was discussion on this in minorities committee. Many things may not be exactly worship, but maybe in the sense practice of that religion. You may have to, for instance, the immersion procession of Ganpati. It is not worship, but practice of religion. If you go to the temple, it is worship. Further than that, it will be practice of religion. See Rajgopalachari. The second difference is the right of propagate. Propagation comes under freedom of expression. There is a sharp difference of opinion on this, whether worship alone, whether it may be, should be allowed, or whether practice should be included in our fundamental rights. My lord, it was with a view to whether to widen it or not to widen it. My lord, eventually, my lord, it was widened. My lord. Kindly, my lord, turn to the next page 24. My lord, I'm not troubling your lordship. Your lordships have any?
Yes.
But did I miss the query, my lord?
No.
I'm sorry. My lord, please come to page 24. I'm just, my lord, shuffling this through, my lord, because it may not have direct relevance. We'll read 25 textually, and this is how it is interpreted in the judicial pronouncements. Now, my lord, please come to 27, my lord, instead of this. My lord, the rest, my lord, may not have any. My lord, this is regarding, of course, conversion. My lord, the chairman ultimately, my lord, puts it to vote, and ultimately his decision, somewhere in the 10th or 15th line from the bottom, highlighted part, chairman, I
consider
these are matters to be left to legislation. With the concurrence of the House, clause 21 was deleted, which provided in a fundamental right chapter that conversion should be prohibited. Sardar Patel says this is a matter of legislature. It is already a penal offence. Let us leave it to a legislature. We may take up clause 22. This clause 2 is unnecessary and may be deleted. But please see next page, chairman's final verdict. That was forcible conversion. Forcible conversion is no conversion. We won't recognize it. But ultimately he says that there are laws and there can be a law. There need not be a fundamental right either way. Then kindly come to 29.
There is a difference between propagating religion and forcible conversion.
Converting.
Here, what is protected is propagation of religion.
Yes, not by force or inducement or by coercion, etc. That's exactly, but I didn't read it, but these were the words used by everyone. That if you are converting someone because of force, inducement, threat, coercion, then it's no conversion at all. You can propagate, you can convince someone, you can say this is the better things of my religion, etc. Now, my lord, some questions, my lord, your lordships have framed one question. Why was it opened only for Hindus? Article 25 2b says that all Hindu religious places shall be open. All public religious places of Hindu religion shall be open for all sections. My lord, your lordships would get something, my lord, in this. 1st May 1947. The Constituent Assembly meeting in New Delhi took up Sardar Patel's interim report on fundamental rights. Debate was relatively limited. K.M. Munshi moved to add a specific provision that religious freedom will not prevent laws for throwing open Hindu religious institutions of a public character. I'm reading page 29,
29.
PDF 31, 32.
The top.
I'll read again. The Constituent Assembly meeting in New Delhi took up Sardar Patel's interim report on fundamental rights. Debate was relatively limited. K.M. Munshi moved to add a specific provision that religious freedom will not prevent laws for throwing open Hindu religious institutions of a public character to all classes and sections of Hindus, directly targeting exclusion of Dalits and lower caste from the people. But this was the idea, because we unfortunately were living in a society where one particular part of Hindu was not permitted to be a part of the broader Hindu denomination by denying them right to worship. Again, this had nothing to do with gender. We last decade or so, there is a jurisprudence which is developed where every constitutional provision will have to be seen from the lens of gender. All provisions are not. There is no discrimination. 14, all genders are equal. 15, irrespective of sex, all fundamental rights are equal. This was, my lord, that era-specific provision, that if it is a public temple or public religious institution, it should be open for all. We must do away with this untouchability, etc., section within the section, etc., which was very rightly accepted. I'm highlighting because one judgment has said that this is to ensure that even women can enter. Women were entering all temples. I'll come to that, my lords. Then, my lord, next page, last part. Why section thereof word was used in the, so far your lordships have seen Article 25 did not have the word section thereof. It was only religion. Now it comes because K.M. Munshi, my lord, all were visionaries, my lord. Alladi Krishna Swami Iyer, K.M. Munshi, there were many, my lord. If I name, I would be doing injustice to some other people, my lord. But K.M. Munshi, sir, I move an amendment that in clause 14, the word or a section thereof be added between the word denomination and the word shall. It was felt that the use of the term religious denomination may prevent a section of a denomination from being protected. Lord, no judgment has noticed this part. Sabarimala does not notice even the expression section thereof. It says that Sabarimala or Ayyappa Swami is not a denomination at all. That temple is not a denomination because it is a larger part of Hinduism. So no protection under 25-26. Therefore, I gave an example of Ajmer Dargah, where everyone goes. It's a section thereof. In Shirdi, everyone goes. It's a section thereof. In Tirupati Balaji, all Hindus go. Shaivites, Shaktyites, Vaishnavites, everyone goes. But it is a denomination because it takes care of faith and belief of a section of the Hindus. So denomination and a section thereof, that was suggested. And no judgment takes, Lord, at least Sabarimala does not even notice whilst holding that Sabarimala is not a denomination, because it is a Hindus also go and Muslims also go. And I can give 50 examples of shrines places, dargah, where all community people go, or places where, for example, Dwarka, Srinathji, it is essentially a Vaishnavite denomination, but Shaivites also go, Shakta Sampradaya also go, every Sampradaya goes. So you cannot say that it is ultimately Vaishnav denomination, and therefore it would not get the protection of 25 and 26. Therefore, the word section thereof. Page 32. My lord, in this court, yes, yes. Exactly. Balaji. Lord, I'm sorry, my lord, if I'm going little. Lord, in case of Dargah committee, my lord, that is Ajmer, the five judges bench of this honorable court did held that it is a denomination and it is rightly held. One of the reasons why it was referred to was this anomaly. That why, how can you, it's a section thereof. Why are you not doing it? Lord, the only problem with Dargah committee was, for the first time, it introduces essential religious practice doctrine. And it goes to the extent of saying that not only essential religious practice, even superstition is not protected by 25 and 26. Nobody says superstition should be protected, but who will decide whether it is a religious practice or a superstition? Courts certainly cannot decide. If it is a superstition, I'll give your lordships, I have compiled laws which prohibits superstitious acts under Article 25(2)(b), social reform. There are acts, my lord, against black magic, against, my lord, several. I'll give, my lord, the list of laws. So superstition can never be a test for deciding whether it's an essential religious practice. But kindly say practically, if some particular practice comes before your lordships, my lords will have to first decide whether it is a religious practice or not. How can that be decided? You will have to interpret the concerned religious text. Concerned religious text, my lord, would be interpreted by several scholars, my lord, by what we call in, my lord, Hinduism, Bhashya. Bhashya is a commentary, several commentary. If Holy Quran has hadiths, have several other documents, you will have to examine all in juxtaposition and try to understand what is meant when it was written, which is now the sacred text, which is impossible. We also will not be able to assist.
Mehta, are you suggesting that at a certain point of time, at a certain stage, the court may not into the domain of deciding the essentiality, which probably would be a little bit more than the court should be asked upon to interpret?
Lord, I am on a judicial review that this is a domain which may perhaps not fall within the judicial review domain, irrespective of the religion.
There is a difference in the nature of the proceeding in which a question of a religious practice or not an essential religious practice may lie. Don't only see it from the narrow compass of Article 32 or 226. It may be in the form of a civil suit also.
That is one of my submissions. My lord, as I go further, your lordships would find I have not pitched my submission at a higher threshold.
If your proposition is taken to a logical conclusion, then courts are not essentially experts in matters of science, but the Evidence Act empowers the court to examine the opinion of experts and become an expert of experts.
Correct. And take assistance. That's why one of the
33 or 32 customs, usages, practices. There is a provision in which the law permits the court to use objective parameters to come to correct subjective decisions in the facts of each case as to whether it is a long-standing practice, usage or not.
Probably the difference is here. Science is based upon logic and reasoning primarily, where religion is based upon belief.
Faith and belief. My lord,
Then-
there are two answers, and
Then
I'll come
what
to that.
extent we can go into the aspect touching upon belief
Yes.
with a little understanding, as you rightly said, without
I'm going to, my lord, address little in detail on essential practice. Why I highlighted is, first, your lordship will have to decide what is religion. Then second, it would be whether it is essential part of the religion, which would be very, very difficult, and if I am permitted to say, difficult to decide. And third, your lordship will have to say whether this needs examination or not. I have devoted one 2-page chapter on this, that even if it is necessary, kindly give me a...
My question is not a quick opinion in any way. I would just want some.
Understood. No, it's just a...
You enlighten.
Elucidity.
Yes, yes.
My lord, what has happened is, my lord,
Because there is a difference between an opinion as to faith and the faith perceived. One can have a particular faith, but whether that faith, opinion exists in that denomination or not can be separate from the testing of what is the faith itself.
Lord, I would answer, my lord, when I come to that, but my immediate response is this, that...
Because a religious head says, this is my faith, and the followers abide by that. The fact that this is my faith, stated by the religious head, is something which is within the domain of the court to apply the appropriate forensic criteria or tools to decide. But whether that faith actually exists or not is for the religious head.
Rationality or scientific nature of it cannot be gone into. My lord, that's correct. My lord, that's a correct approach. My lord, what I have suggested, my lord, as I go further, my lord, there are two things that your lordships can decide.
We are fully conscious that when we see Article 25, Article 26, it is an unique capsule which must be seen in contradistinction to fundamental duties of scientific temper.
Correct.
Because there may be a faith in the existence of an all-encompassing, omnipotent power, which the scientific temper or scientific experiments may not divulge or unravel as of now. That may not be a question which courts will ever enter into. But whether such a faith existed amongst the members of a particular denomination or a part of denomination can be a issue framed in a suit between two groups or even intergroups.
I'm fully, my lord, in respectful agreement, but not the question whether it is essential part or not. And second, and my lord, I don't want to jump the gun, there is a separate chapter. If it is found to be by a legally trained mind, either unscientific or illogical, only a minute.
Really relevant at all when we come to faith.
Only a minute, my lord. Your lordship finds, my lord, that this is something unscientific, not palatable or something. The remedy is for the legislature under the social reform.
Social, right.
Second, Lord, I have also devoted one chapter that in case if it is required to be gone into whether this is a religious practice at all, the remedy would be a civil suit where the parties can lead evidence, examine expert witnesses, experts on the subject, which will have the court will have the assistance of those expert witnesses, and based upon the totality of the facts, the court would examine whether this is religion or not. It cannot be that there is nothing in affidavit which satisfies us that this is an essential religious practice. That is done. This is a part of judicial review. Therefore, my lord, I'm not, my lord, for a second saying that 32 or 226 would never apply. I'm only on the extent of judicial review.
So we understand your submission is not on justiciability, but the forum at which the...
No, justiciability also. And I'll, my lord, make my submission. Yes.
You will make it.
Justiciability also, my lord. That's, my lord. I must make it clear. Lord, it may meet with your lordship's acceptance or not, but justiciability, and in most of the cases, the forum also. Suppose, for example, in some religion, some person claims that right of human sacrifice has been a practice in our religion, and it is an essential religious practice. He comes before your lordships under 32. No evidence is needed. If some example comes before your lordships which directly hits either public health, public order, health, or morality, your lordships would not be required to go into whether it is religious or not, whether it is an essential part or not. And your lordships can say, no, this is contrary to morality. I can have, for example, but any, my lord, I don't want to give examples which are immoral examples.
So we take it. So let us take the Sabarimala case. No? Rules are also challenged. There is a forum by which rule can be challenged. So 226, you can always do it. But according to you, if you can reframe what you are saying, the power of judicial review over the constitution of the rule is rather limited according to you.
Yes.
With that extent, we can put it.
Yes.
Notwithstanding whether suit is edible, suit also can be filed challenging that.
And it can.
Suit also can be filed.
It can be challenged.
But you can say that court should be chill. Certain areas you can venture into, like competency and other things.
Yes.
Legislative competence, those things you can consider into.
Arbitrariness.
But court cannot substitute itself.
Yes.
With the available material, and then how do we can't
based on affidavits that it is a religion, non-religion. It's not a part of religion.
Whether
it is essential or not, that is, my lord, something a second guess which may be done in given circumstances. Suppose cannibalism. Somebody says that cannibalism is a part of my religious practice. It's immoral. Your lordship doesn't need to undertake any theological exercise. Lord, in Pakistan and some other countries, there are, Lord, the courts, what is called, Lord, ecclesiastical courts, Lord, which are specially, Lord, constitutionally created courts.
Rather, we can go into the decision-making process, but not on the decision.
Merit review is not permitted. Well, that's what, my lord, my submission. In a different format, I'll make it good. But in my lord, these courts, which are constitutional federal courts, my lord, the judges are having legal expertise as well as ulemas. They sit together and decide whether it is a part of religious practice and whether, if at all required, it's an essential part of religious practice.
In other words, if there is a social ill which is being branded as a religious practice, the court can certainly distinguish between the two. A social ill or an evil and an essential practice of religion.
Well, essential practice is a separate issue, but if it is a social evil, the answer can be
because
yes.
Many social evils are given a religious color, but the court can always distinguish it.
Certainly, but but the real answer in law, the constitutional answer would be the remedy, even in case of an evil, would be 25(2)(b, which says for social welfare and reform, the legislature can legislate. Correct. And there are legislations which I will show that they are, the legislatures are not passing such laws. Well, I'll just finish this and
Article 25 is a balance between what was existing and what has to be done in future. What has to be done in future is left to the legislature. But the Constitution also tries to preserve what is already existing in Article 25.
But I'll go a step further.
There is one overarching, that is, it is subject to public order, morality, and health when it comes to freedom of conscience,
and part 3.
And propagating.
And part 3. In 25, part 3. Correct. Even if there is a the practice which is in vogue at the time the Constitution came into force, even that can be subject matter of 25(2)(b, reform law, or for social welfare. Something which may be good for the society or maybe bad for the society and continued, can still be reversed by the legislature by preventing it, regulating it, prohibiting it, whichever way the legislative wisdom goes. Now, my lord, kindly come to page 34. I'm just going to quickly run through and come to my lord Sirur Math. This is conversion. My lord. I'm not reading it. Kindly treat it as read. Lord, ultimately, they say, yes, that send back to the advisory committee an advisory committee, my lord, comes back and it says that it is an evil, but it is already penalized and it can be penalized. That's all. Now, please come to page 38, my lord. The PDF would be 41. 41. Now, any class or sections of Hindus. My lord, please bear these in mind right now when I read 25 and 26. My lord, your lordships may have the background why these were added. That's the purpose. This note is our note. Yes. My lord, this is the note which I have said. My lord, this is the note of Sir B.N. Rao. Not note, our note, my lord, in our written submission. It's a note part of the debate, my lord, of the record. The expression any class of sections of Hindus or class section of Hindus used in subsection B of clause 2 of article 19 will not prevent the making of any law for throwing open Hindu religious institutions of a public character to all classes and sections of Hindus. There is, however, no objection to the amendment. Discrimination on the ground of caste, etc., is forbidden by Article 9, which is 17 now. But Sabarimala says that all sections of Hindus were introduced so that it is gender specific. But it is not gender specific. But as a matter of fact, I'm sorry, but one opinion in Sabarimala says that Article 17 applies to women. You are treating women as untouchables. That's the opinion. One opinion, my lord. That's something I have a very, very strong exception to it. Therefore, I am insisting all sections of Hindus had the background of all castes, not gender. My lord, India is not that patriarchal or, my lord, gender stereotype society as the West understands. Sometimes that's the problem.
The question of untouchability has its own history
Yes.
in India, and therefore to get over that, Article 17 was made a fundamental right. Untouchability in the context of the Sabarimala, I don't know how it will be argued.
It can never be justified on untouchability. It can, I'm putting, my lord, that straight.
Speaking as a woman, I can say there can't be 3-day untouchability every month. And on the 4th day, there is no untouchability.
No, I understand. No, I'm not on my lord, menstrual
cycle. Go by the hard realities.
My lord, but entry of
the other aspect is the main question.
We fully agree with this.
And speaking as a woman, Article 17 cannot apply for 3 days. And on the 4th day, there is no untouchability.
My lord, I have no issue or dispute with that. Sabarimala, I'll defend in my own different way. Without, my lord, Sabarimala does not mean 4 days. Sabarimala means a particular age group. And let us be very clear, if there is any confusion in anyone's mind. Lord Ayyappan temples throughout the world are open for all sections of ladies, except one particular section, my lord, temple, my lord, which is a sui generis case. There are 3 temples, Lord Ayyappa temples, my lord, to my knowledge, my lord, in New Delhi, all, my lord, right from child till, my lord, old women, everyone goes and worships. It is only one temple. Lord, there can be a denomination and denominational practices which we have to respect. Lord, everything is not relatable to human dignity or individual body freedom. My lord, if I go to a mazar or if I go to, my lord, Gurudwara, if I have to cover my head, I cannot say that where is my dignity? You are taking away my right of choice. This is what Sabarimala says. Your right of choice is taken away. Your autonomy is taken away. It's not taking away of the autonomy. It is respecting the tenets, the faith, the belief of that religion. When we go to, my lord, Ajmer Sharif, we do wear, my lord, we do cover our heads. When we go to a Gurudwara, we do cover our heads. And nobody, my lord, says that this is bodily integrity, my lord, but this is, my lord, has slipped in, my lord. There is a new, my lord, jurisprudence which is developed. My lord, I'll bring your lordship's attention to that. But it's saying this, my lord, all sections of Hindus is meant to mean no caste-based discrimination.
That is the first question, Mr. Solicitor. That is the first question. That 26, preserving the right of religious practice or managing religion by a denomination.
Religion affairs.
Prevails over 25. That is the right of every individual to conscience and to practice. So there is a stratification of 25 and 26, with 26 supervening 25 rights.
Lord, there is divergence of view.
So that is what you are trying to, I'm just trying to formulate what you are trying to respond to the first question.
I'll come to that, but immediate answer is this.
Supervening 25.
No, that's not my, well, therefore I said, I am not raising any of my arguments at a plane, which becomes...
So far you have not raised any argument, you are only...
Yes. It is historical background. But my answer, immediate answer, and I'll finish this. 26B is not a standalone island. It will have to be read with 25. And other parts of the Constitution also. Now, today, my lord, after Coelho, after my lord, TMA Pai, and after R.C. Cooper, we cannot say that any fundamental rights is an island and it cannot take color from any other fundamental right. Article 25 and 26 also will be governed by 14 and 15. That is no gender-based discrimination. I'm not pitching it high. Sabarimala is a sui generis case. On facts, I'll defend.
Interesting difference. 25 makes it expressly subject to other...
I'll come to that.
26 is unshackled.
Unshackled.
26 unshackled.
Yes, that is, my lord, a possible view. My lord, that, but there is a view, my lord, on this side, that it should be a separate island. 26 is unfettered by any provision.
Putting it that high.
I am not putting it. My lord, it would be unfair, my lord, to putting it that high, that one article of any fundamental right chapter can be an island and we can do anything, my lord, we want. That's
not anything. It's subject to moral.
Oh, of course, my lord.
And
not
health.
Part 3, not Part...
Health. Definitely not cannibalism, as you say.
Lord, there are some arguments on our side. There are some arguments on our side which says that 26B cannot be read even with 25(2)B. Even there cannot be any law for social reform or, my lord, which takes away 26B, right? Which, according to me, my lord, is too high, my lord, interpretation, my lord, to be given. Now, my lord, I'm through with, my lord, this. I'm not, ultimately, my lord, it comes to what 25...
Mehta probably will have to also address, because we should not stretch the consideration to a point where we consider all Lord Ayyappa temples in one frame. This has to be specifically with only one. As you said, that all others, this is not the restriction. It is only in one special temple.
That's not, my lord, my submission. My submission is that 25 and 26, as my lords have used the word, is a capsule. It will have to be read together. And 26 also may take color from other fundamental rights. I am saying...
I'm not with what Brother...
I am only saying Sabarimala is a sui generis specific case. There may be other temples having their temple-specific peculiarities.
So this has to be specific to that.
I am saying Sabarimala I am not right now touching. It's a sui generis case. I am not saying there may be other temples also, where there are some... For example, this is attribute of a deity. In Ayyappan Swami case, it's an attribute of a deity. How would we judicially examine? Can attribute of a deity be ever subject matter of a judicial? With that, I'll come to that. Please come to...
It's not a mere practice, it is connected to the belief.
Faith and belief both.
So it will be a little bit more.
Yes, Lord, therefore, kindly now come to 25 and 26, and then I'll directly come to Lord Shirur Math. Okay. My lord, 25. First, see, my lord, the title of the chapter, Right to Freedom of Religion.
Also, I give you an answer for European general Islam.
Lord, the subtitle of part 3 is Right to Freedom of Religion. Correct? Now 25. Freedom of conscience and free profession, practice and propagation of religion, subject to public order, morality and health, and to other provisions of this part. Lord, it is specifically made subject to part 3. All persons are equally entitled, equally is a manifestation of secularism, I have said, to freedom of conscience and right freely to profess, practice, and propagate religion. So, first word which is used is religion. Then, 2, nothing in this article shall affect the operation of any existing law or prevent. Am I with your ladyship, my lords?
Prevent the state from.
Yes, ma'am. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law, A, regulating or restricting any economical, financial, political, or other secular activity which may be associated with religious practice. Now, please see, my lord, this is practice of religion. First is religion. Second is while you practice the religion, there may be something which is either economical, financial, political, or secular, and that can be regulated or restricted by the state. Now, B, providing for this again, my lord, is a right or negatively couched, my lord, provision that state is not prevented from doing what? Providing for social welfare and reform. This is the power specifically conferred. And this, in my submission, is not confined to any religion. Now, second part, or, which is disjunctive, throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. I have already pointed out that is a caste-specific intention being reflected. So, for all religions, there can be a law either providing for social welfare or providing for reform. And all religious places, nobody can say that one particular caste will not be able to enter temple of another caste. My lord, forget 17. My lord, I'm taking a little broader version, my lord, vision. My lord, there can be a possibility, unless we read it this wise, that one temple of one particular denomination, say X caste of Hindus, may prevent another section of another class of Hindus who are not protected by 17. We will be dividing the society if we read it that way. Therefore, I am not reading.
I didn't get it, not very clear, your submission.
Yes, I'll my lord, again point out, my lord, I'll make myself clear. My lord, I'm explaining why there is a mandate that you can make a law for social welfare and reform for all religions. No dispute. There cannot be any dispute. Why the word used is throwing open of Hindu religious institutions of public character to all classes and sections of Hindus. It has a noble idea. And the interpretation which I am trying to give is that forget, Lord, those who are covered by 17 scheduled caste persons, my lord, who were traditionally earlier not permitted to enter the temple. It is not mentioned in this provision that it is only confined to permitting clause article 17 people. Why? Unless we take that view, lord, both of us are Hindus. I belong to a particular denomination. He belongs to another denomination. There is a temple of my denomination. He is not covered by 17. He is not a Dalit. But let me put it straight. He is not, my lord, a scheduled caste person. But for this, I can prevent him also. There would be division amongst Hindus. There can be a division inter, say, Muslims. That is why Muslims would not come, because this is only for Hindu religious institutions. Unless we give this interpretation, there would be a serious danger and apprehension of society being again divided on caste basis, not, my lord, based on Dalits versus non-Dalits. And power is with the legislature.
Class and section.
Yes,
Right,
yes.
2 words there.
Class and sections, my lord. 2 words, my lord, to make it very clear that suppose, my lord, there can be more than one category of Dalits. So class is Dalit, but there can be, my lord, other sections, my lord, that Dalits will permit, but a category of Dalits we will not permit. It can be, my lord, different.
Backward class under Article 15(4), socially and educationally backward.
No, my lord, suppose, my lord, we say, it may be, my lord, suppose occupation based. For example, that Dalits are permitted, but those who are doing, my lord, activity of manual scavenging will not be permitted. Or those who are dealing with leather of the dead animals will not be permitted. Therefore, to be on the safer side, they say that all classes and sections of.
Pointedly, your argument is that class and section cannot mean and include gender.
Gender, yes, ma'am. It's overarching.
Excludes gender.
Why? And I am not saying that means gender can be prohibited. That is.
But this would not.
It's not intended for that. It is intended for the caste situation existing in 1947 when the constitution was framed. The gender equality is already there under 14 and 15, that you cannot discriminate based on sex.
But then the KVPs should be a public character.
Public character.
The institution must be of a public character.
Public character.
It's a private character.
Not, yes, but there are some private temples. There are private temples in this country, my lord. Therefore, the framers of the constitution have risen from the rank. They have played on Indian streets. They knew the hard realities of life, that what is happening in the society, and they were giving a constitution which deals with all these issues. That there are private temples, public temples, one particular caste is not permitted in some particular temples, etc., etc. And therefore, this was a reformist move specifically by the constitutional makers, leaving rest of the reforms for other communities, including Hindus, other religions, including Hindus, to the state.
The form of assimilation of Hindu society.
Yes. And no.
Deep divisions
and
within Hindu society.
And preventing discrimination. These were, my ladyship is right, these were the 2 things. Then, my lord, explanation 1, we are not concerned, Kirpans. Then, my lord, 2 also, we are not concerned. It says Hindus include Sikhs, Buddhists, Jains, etc. It's not a question of dispute. Now, see 26. Freedom to manage religious affairs subject to public order, morality, and health. Your lordships are right. It specifically absent, there is a conspicuous absence of textual words, other provisions of this part. So it is capable of reading in 2 ways, that it is a standalone island provision. It is not shackled or inhibited by anything in either Article 25 or any other fundamental right. Second interpretation, which, my lord, I personally subscribe to and I assist your lordship with, is that 26, in the present day, the way jurisprudence has developed, jurisprudence says that no article in part 3 is an island. It is always to be understood with some other articles of the Constitution, other fundamental rights. That's how what they call harmonious construction. That's what Devaru judgment does.
Yes, you are right.
Thank you. That's what, if the other side, my lord, agrees with me, I immediately am on my alert. There is something seriously wrong in my argument. But yeah.
No, there should be harmony also between all sides here.
But here we are.
No one is island.
No, my lord. Otherwise, this was on a lighter side because no one here should be arguing for succeeding or losing. We are assisting your lordships to answer questions, and those answers which have large-scale ramifications for decades to come. Therefore, my lord, it has to be, my lord, the assistance, my lord, rather than any adversarial thing. Now, please see, subject to public order, morality, and health, every religious denomination or any section thereof shall have the right, A, to establish and maintain institutions for religious and charitable purposes. Only these two. Earlier, my lord, the term religious which was used in the then 30 is deleted now. B, to manage its own affairs in the matter of religion. This is, my lord, what is falling for your lordship's consideration. But D also, C and D your lordship may read, because Sirur Mutt was dealing with D. To own and acquire movable and immovable property, no dispute. To administer such property in accordance with law. So this is, my lord, shackled by one condition, that if there is a law prescribing your administering the property, your right to administer the property would be in accordance with law, if made. Correct, my lord? This is the textual meaning. Now let us, my lord, start with Sirur Mutt. How this is, my lord, considered in Sirur Mutt. The relevant parts, my lord, I have quoted for your lordship.
Solicitor General, in the context of the Sabarimala controversy, how Article 26 is relevant?
My lord, their argument was, I'll just answer. The argument was that it is a denomination. 26, as your ladyship has noticed, is a denominational right.
I didn't agree that it is a denomination, that it applies, that the temple is open to all Hindus and not related to a particular
argument
or something like that.
Argument was that it is a denominational temple and therefore 26 would apply. The court held that it is not a denomination,
Yes,
without noting section thereof, saying that it's a Hindu temple ultimately. Section thereof is not. B was placed into service to say that it is the right of this denomination to manage my affairs. And managing the affairs means that there is a faith and belief that particular gender of particular age group would not be permitted. So the court said that first it is not a denomination, and it says that 26B is given an expansive meaning. I'll come to that.
26 does not apply if they held, majority held.
It was not necessary to go into the second question. I agree.
No need of Article 26 being applied.
No, they have also.
Or so to say.
No, I'm sorry, but there are 20, 30 pages written on Article 17. What is the meaning of Article 17? Well, I'll come to that, my lord. I have a serious views on, my lord, some of the paragraphs, my lord, and I'll.
We need not go to Sabarimala.
No, we are not going to, not Sabarimala, not
Sabarimala. To understand one. 25 is with the temples, Hindu temples of public character. 26 with the deals with the denomination. Not for there. Only commonality is that both of them will make clear that is they are all subject to public order, morality, and health.
Correct, my lord.
You there travel on the different channels.
No, my lord, I'm not on.
Little bit overlapping.
I'm not on. I'll not argue review on Sabarimala, but the journey of judicial evolution from Sirur Mutt ends at Sabarimala. So in that process, I'll read Sabarimala. That's all, not for review. This is how there is a shift.
So solicitor refers to the 9 judgment. There will be 7 questions are there. At least question number 2 and 3, they directly pertain to Article 26. Therefore, essentially, arguments will have to come for both sides on 26 also, and probably will have to respond to that.
Correct, correct.
So ultimately, it may or may not have any direct or indirect impact while deciding a particular case. But what is the true meaning and scope and import of that article? Probably that is required to be gone.
May I only add one part with your lordship's permission? When your lordship says that judicial policy will have to be evolved, how to deal with such issues. So I'll have to show, without going into how Sabarimala is right or wrong, that it started with Sirur Mutt, and this is how the judicial exercise is undertaken for 25-26 in Sabarimala, without giving, my lord, anything that whether it is right or wrong. But I can always read it as a part of the judgment, because the journey starts from Sirur Mutt and ends at Sabarimala. Now it would finally end, my lord, by what your lordship decides. Now, my lord, kindly see.
Hopefully.
Yes, my lord. Your lady.
Or a new journey begins.
Yeah, but yes, my lord, that also. Because broadly, there are three eras, my lord, of this evolution. First is Justice B.K. Mukherjee era. And Justice B.K. Mukherjee was, apart from being, my lord, a scholarly judge, was also an expert in Hindu law. That was first era. My lord, then comes the second era, that, my lord, where Justice Gajendra Gadkar era. I'm not in any other sense, my lord, just to define. Then third comes Veeraswamy era. Justice Ramaswamy era. Some three judgments, my lord, with which I'll my lord, show some.
Probably 4 or 5 judgments.
With all our 5 judges, Justice Ramaswamy is in 3 or 2 judge combination. And fourth is, my lord, this last decade, my lord, the new jurisprudence which is
Manifest arbitrariness and constitutional morality.
Constitutional morality.
Do we use constitutional morality in interpreting the encapsulation of freedom of religion rights between 25 to 20?
It can never be a test. It can never be a test for judicial review. It is something else.
It's faith versus constitutional morality.
Faith, belief, worship. Constitutional morality is some, I'll not show. Constitutional morality, even this court has not understood as a part of judicial review. It says how governors, prime ministers, president, constitutional functionaries under the constitution have to act. It's a political doctrine. It's not a doctrine for judicial review. And that is how in Keshavanand Bharati it is understood.
This is why, Mr. Solicitor, I was putting the question, what would be the import of the absence of subject to other
my lord, I'll be addressing. My lord,
provisions
let me.
of the part 26 and making 25 subject to other provisions. Because 17 definitely you have addressed, but there is also 15.
I'm addressing that also.
And therefore, when it is subject to other provisions in 25, subject to 15, equality cannot be taken away on the ground of sex, articulated further into gender.
Even 14.
But 14. But if you see 26, it's not subject to it. We are fully conscious of it being compatible with others, but not subject to it.
Lord,
there is uniqueness in a particular denomination to say this is how our worship is done, or this is how the religion we understand as salvation to our deity. Can that be tested against the paradigm of equality under 14 to 16?
Lord, I have given, my lord, the answer to that. My lord, the answer is that neither 26 is supreme or superior, or 25 is subordinate or dependent, nor others, my lord. And that's how Devaru answers this precise question, that the interpretation will have to be purposive, reading 25 and 26 together. That's, my lord, according to me, is a correct position on law for that purpose, my lord. Can I?
Actually, Article 25 is with regard to, from the preamble, right, freedom of thought, belief.
Faith, belief, and worship.
Thought, faith, belief.
And worship.
Worship is a manifestation of that belief and thought. It is a manifestation. And Article 25 is related to conscience, which is also part of that. But Article 26 is not related to conscience as such. It is only a freedom to manage religious affairs.
The reason is,
Totally different area.
your ladyship is right. The reason is 26 is a denominational right, and denomination cannot have a conscience. Not only individuals have conscience. 25 is for individual or group of individuals, and therefore the word conscience is used. 26 is denomination specific. Lord, now, my lord, I am in 3 parts. Lord,
Any section thereof.
Yes, any section thereof.
Also, food for thought, so better you answer it after lunch.
After that. Obliged.
My lord, may I make a request, please? My lord, not, I am very aggrieved. My lord, one by one heinous crime committed against me and my family because of injustice. Me and my mother living on road. My lord, 2016 run over the car intentionally by some accused my mother. My lord, after behind for the grab of 89.
What do you want?
My lord, please kindly heard me. My lord, 2016 run over my mother intentionally by some accused behind some politicians grab of 90 crore property. My lord, after that one, my lord, kindly heard me. I am very aggrieved.
No, I'm saying something for your benefit. You please need not to tell the facts that we will find out when the matter is listed. What do you want? You want your matter to be listed tomorrow? You want your case to be listed on Friday? You want your case to be listed after?
My lord, kindly heard me. After that, I tell you, my lord, intentionally ran over my mother by some accused for the grab. Kindly for the grab of.
प्रेयर क्या है? आप रिलीफ
सर वही मैं बता रही हूँ आपको. प्लीज हेड मी. वन बाय वन हीनियस क्राइम कमिटेड अगेंस्ट मी एंड माय फैमिली. Run over my mother 2016 intentionally by some accused. After 1 week FIR register and after 2 months 1 accused arrest and 7 not challan produced. By 2020 my brother murder but not register FIR, not I file petition in High Court. After 2-3 years संदीप मुदगिल ऑनरेबल जस्टिस संदीप मुदगिल सर ने उन पुलिस वालों को बुला के डीजीपी तक को बुला के डांटा कि एक हमारी कोर्ट की वकील होके वो बेचारे 2-3 साल से धक्के खा रहे.
पंजाब हरियाणा में प्रैक्टिस करते हैं?
हाँ, यस.
कब से करते हो आप?
हाँ जी.
कब से कर रहे हो प्रैक्टिस?
2016 से.
16 से?
यस माय लॉर्ड. फिर ऑनरेबल जस्टिस संदीप मुदगिल ने फेवर ली मेरी. काफी जजेस ने ली पर उनको कोई फर्क नहीं पड़ता. और 2022 में हमारा जो बड़ा सा घर है उसमें घुस के सारे मेरी मम्मा के गोल्ड भी उठा लिया. उल्टा भी वहां पर प्रोटेक्शन मिली हुई थी मुझे हाई कोर्ट की, जबकि प्रोटेक्शन के बीच में ही वहां से गोल्ड भी सारी एसी वगैरह पूरा उस घर को डिस्ट्रॉय भी कर दिया और थेफ्ट भी कर दिया. जैसे और वो बोलते हैं ये प्रॉपर्टी बेच दो या सर. उसके बाद भी कुछ भी वहाँ हाई कोर्ट के ऑर्डर हो रहे हैं, कुछ भी नहीं हो रहा. और मेरी मम्मा और मैं रोड पे हूँ और पुलिस तो हमें ही तंग करती है. कभी झूठा केस बना दे.
रखा है किसी जगह पे? सर
वहां पर हाई कोर्ट में तो ऑर्डर हुए फिर भी मैं कहाँ जाऊं. मेरे तो सारे पैसे भी घर में. मेरी मम्मा को बेचारे
आप एडवोकेट हैं, आपको तो ये क्वेश्चन करना ही नहीं चाहिए आप कहाँ जाएं. अगर हाई कोर्ट का कोई ऑर्डर आपकी फेवर में है.
सर सारे ऑर्डर फेवर में है फिर भी कोई फर्क नहीं है. वो तो हमें भी मार देंगे. बीच में हमारे घर भी घुस गए, जमीन में भी घुस गए. हाई कोर्ट वाले जजेस तो बोलते हैं हमने ऑर्डर दे रखे, हम क्या करें.
नहीं ऐसा कौन सा जज ऐसे बोलेगा कि ऑर्डर दे दिया. मैं
सर
ऐसा कोई जज नहीं
सर सारे जजेस. मैंने ऑनरेबल जस्टिस चीफ जस्टिस रितु बारी के यहाँ भी मैं अपीयर हुई. उनको बताया कि ऐसे ऐसे वहाँ 2 पुलिस ऑफिसर बोलते कि बाहर आपको प्रोटेक्शन के लिए खड़े हैं. अगर प्रोटेक्शन के बीच में कॉन्टेम्प्ट डाली है पर कोई भी आज तक पकड़ा भी नहीं, उसको कोई भी FIR भी नहीं. सर ये कोई अंग्रेजों की कंट्री में थोड़ा ना रह रहे हैं कि हमारी प्रॉपर्टी के लिए ना. मैंने हर चाइना से अपने कोर्ट में भी वकील होके सारा बताया. सर FIR रजिस्टर होती है उसको कैंसिलेशन के लिए भेज देते हैं. मैं कब तक कर सकती हूँ. ना तो हमारे घर में घुस के सारे पैसे भी उसको.
आप बात सुनेंगे ना, आपको कोई हम देखो सलाह दें. या तो आप हाई कोर्ट में जो आपके ऑलरेडी ऑर्डर फेवर में है और अगर वो ऑर्डर इम्प्लीमेंट नहीं हो रहे या उन ऑर्डर्स की एक्सिक्यूशन नहीं हो रहा तो आपको पता, आप खुद एडवोकेट है, आप हाई कोर्ट में कोई पिटीशन फाइल कीजिए, आप कंटेम्प्ट फाइल कीजिए, एक्सिक्यूशन.
सर सब करके देख लिया सर. कभी भी
यहाँ पर वर्बली आप बोलेंगे, वर्बली मैं क्या कर पाऊंगा आपको. आप यहाँ कोई पिटीशन
सर मेरे पास ना तो कोई पैसा छोड़ा, मेरी मम्मा को गाड़ी के नीचे दे रखा है, भाई को मेरा मार दिया, और इतने 2022 से मैं 4 साल से हाई कोर्ट में जा रही हूँ, वो ऑर्डर दे रहे हैं तो कह रहे हैं पुलिस वाले उल्टा मेरे और मेरी मम्मा के अगेंस्ट केस बना देते हैं, वहां पर पॉलिटिशियन और पुलिस मिली हुई है। मैं कहाँ जाऊं बताओ
आप पिटीशन फाइल कीजिए ना कहीं पे कोई कहीं, ताकि हम
सर मैं पिटीशन के लिए आपको मैं बताऊं, नालसा में मैं आई थी 16 जनवरी 2025 में, आज तक कोई वकील उन्होंने, मैंने कहा कि मैं बोलूंगी पर मेरी पिटीशन तो फाइल कर दो, कोई पिटीशन फाइल नहीं हुई। सर ये तो अंग्रेजों वाला हो गया ना कि मेरी मम्मा और मैं तो रोड पे जगह जगह जाते हैं, वो तो प्रूफ ही मिटाई जा रहे हैं, हमारे घर में भी घुस के कोई भी कुछ भी हमारे लिए जो भी कोर्ट, क्या मैं क्या पिटीशन इतनी डाल के भी उसके बाद 1 बाय 1 ही।
ठीक है, देखो अभी इतना आप हमारी पेशेंस भी टेस्ट मत कीजिए आप प्लीज।
सर पेशेंस तो आप मेरे देखो, मैं रोड पे रह रही हूँ ना, मेरी मम्मा बेचारे, फिर अभी मेरे पास प्रूफ है कि पुलिस वाले रात को आके हमारे को उठाने आ जाते हैं। वो तो
आपको नालसा में फ्री लीगल एड चाहिए, नालसा के ऑफिस
सर मैंने आपको बोला ना 2000 पीछे सर
That happens. I know, my lord, that doesn't affect your lordship. My lord, I'll only read.
The case where
No, she needs, my lord, sympathy, and if she wants to be helped, help. But possibly it seems she doesn't want to be helped, my lord.
seems to be whatever may be the circumstance, but
Absolutely.
unfortunately,
It's
she is not maintaining balance.
balance also. Lord, I'll read only two judgments from the judgment compilation. Rest, my lord, just for your lordship's easy reference, and so that I don't bore the court, my lord, by reading unnecessary things, I have highlighted some parts, my lord, so that your lordship's journey, the evolution of law on this point is, my lord, complete. Then, my lord, I would not, then I'll immediately take my submissions on the merits of the case. Well, your lordships may first take Lord Sirur Mutt case.
The compilation by the nodal council or by?
Yes, my lord, it is volume V1, volume Roman 5, numerical 1, 5, numerical 1. Title Precedents.
Starts with BCCI. It starts with BCCI.
No, my lord. It starts with Kantaru, एक minute. Dinshaw Menkenji Petit.
Which volume of precedence?
My lord, it is Roman 5, V, Roman 5, point, numerical 1.
Roman 5.
Roman 5, volume point 1, numerical 1.
It should be here also. Where is it mentioned?
One 60.
Volume 5, is it?
Yes, volume Roman 5, point, numerical 1.
Ah, yes.
And serial number judgment is?
Lord, 5. 160 to 201.
That is,
Commissioner Hindu
that-
Religious Endowments versus Sri Lakshmi.
Your address, I don't have the benefit of seeing of.
Pardon?
Not even there. I'll not have the benefit to read. I'll just talk from memory. This is the way the history behaves. Don't even bother to put it on the record.
No, secretary has not put.
No, it was not put. Only like I checked up.
My lord, as I understand, the nodal councils uploaded on, my lord, the websites.
It is there.
So it is with everyone, my lords.
It's already there. So it is given.
Unfortunately, it is not with me, Mr.
My lord, it is already there. My lord, it is shown in the.
Done it, but the ratio has not done it.
That's white shirt device.
The problem is that it is always.
So read from it's a master. Very fun.
Roman 5, numerical 1, 5.1. Do we have another copy? No. Do we have a laptop or something? Lord, can we share our laptop for your lordship's immediate draft?
Where do I mark?
Sorry.
Where do I mark? 3,000 pages.
Can we give a hard copy? We can airdrop. So it's not there.
That's the rule. Yes. SC, it has to be a SC.
Not here.
I know. Well, as per the circular, the judgment will have to be SCR judgments. Therefore, I think nodal councils have placed SCR judgments. It's more convenient to read SCC. But there is a SOP, my lord, issued by your lordships, by the this honorable court on the administrative side. Your Lordship gets, my Lord, page 160, my Lord the Chief Justice. My Lord, please see the yes, my Lord. Yes, my Lord. Commissioner Hindu Religious Endowments Madras versus Shri Lakshmindra Tirth Swaminarayan. Lord, your Lordships knows Madhavacharya ji started this tradition. There are 8 mats. These are under the Udupi mat.
At least.
Yes, my Lord, it is 1954 SCR 1005. Lord, Udupi Sri Krishna Mutt is, my Lord, the main mutt. There are 8 mutts under, my Lord, Udupi Sri Krishna Mutt. This is one of the mutts. Lord, I would like to show one more thing, Lord, just something relevant. Now, please see the composition of the bench. Because thereafter, my Lord, the next judgment, except to all judges are same. Lord, that, and the judgment is after 2 days, difference of 2 days. Chief Justice M.C. Mahajan, Justice B.K. Mukherjee, Justice S.R. Das, Justice Vivian Bose, Ghulam Hassan, Justice Bhagwati, and Venkat Rama Iyer. Correct, my Lords? Please turn the 162. The date of the judgment is 16th of March, 1954. My Lord, the purpose why I am showing the composition and the date is that the next judgment, which is Ratilal Gandhi, 5-judge honorable bench judgment, my Lord, where same, my Lord, 5 out of the same 7, and the date of the judgment is 18th March 54. So after 2 days. So if there is any confusion about the interpretation of Sirur Mutt, Lord, it would be clear from the second judgment, which according to me there is none. But if Sirur Mutt is read the way, my Lord, sometimes it is read subsequent to this judgment, then it is a wrong judgment. Otherwise, it is, my Lord, a perfect judgment. Lord, this was a case where I am not, my Lord, reading the.
Of both the judgments is Justice
B.K. Mukherjee. Yes, yes, your ladyship is right. Justice Mukherjee. Lord, here was a case in Sirur Mutt. There was a direction issued for the purpose of, my Lord, creating a scheme under the Hindu Endowments Act. That was under challenge, my Lord. The act was also under challenge. Lord, there were 2 proceedings filed. One was a suit and another was writ petition. The competence of the legislature was not under challenge. Competence of the state legislature was not under challenge. Now, my Lord, in this context, please come to page 173. I'm saying, in fact, 172 bottom. 171 bottom. 1016. 16. Subpara. There is only one problem, my Lord, with this judgment, well, according to my reading of the judgment, subject to how your Lordships read, but I'll come to that problem later. The learned judges of the High Court have taken the view that respondent as your Lordship gets, all your Lordships are having. The respondent as Mathadipati has certain well-defined rights in the institution.
Page 173.
171, bottom paragraphs.
The learned judges of the High Court.
Yes, but the learned judges of the High Court have taken the view that the respondent as Mathadipati has certain well-defined rights in this institution and its endowment, which could be regarded as right to property within the meaning of Article 19(1)(f), as it was a fundamental right then. The provisions of the Act, to the extent that they take away or unduly restrict the power to exercise these rights, are reasonable restrictions within the meaning of 19(5) and must consequently be held invalid. The High Court has held in the second place that respondent, as the head of representative of the religious institution, has a right guaranteed to him under Article 25 of the Constitution to practice and propagate freely the religion of which he and his followers profess, to be adherents. This right, in the opinion of the High Court, has been affected by some of the provisions of the Act. The High Court has held further that the mutt in question is really an institution belonging to Shivali Brahmins, who are section of followers of Madhavacharya and hence constitute a religious denomination within the meaning of Article 26 of the Constitution. This religious denomination has a fundamental right under Article 26 to manage its own affairs in the matters of religion through the Mathadipati, who is the spiritual head and superior, and those provisions of the Act which substantially take away the rights of Mathadipati in this respect amount to violation of the fundamental rights guaranteed under Part 26. Well, then your lordships can consider skipping and come to last two lines on this page. So far as Article 25 of the Constitution is concerned, rest is 19(1)(f), we are not concerned. I'm sorry, my Lord Justice Arvind Kumar. So far as Article 20, last two lines, my Lord, at page 172. So far as Article 25 of the Constitution is concerned, the point raised is whether this article, which it is said is intended to protect religious freedom, only so far as individuals are concerned, can be invoked in favor of an institution or organization. With regard to Article 26, the contention is that a mutt does not come within the description of a religious denomination as provided for in the article, and even if it does, what cannot be interfered with is the right to manage its own affairs in the matters of religion only and nothing else. It is said that the word religion, as used in this article, should be taken in its strict etymological sense, as distinguished from any kind of secular activity which may be connected in some way with religion but does not form an essential part of it. Please mark here, my Lord. Please pause here. It does not say essential part of the religion. The doctrine, which wrongly, according to me, is developed subsequently. It says religion but does not form an essential part of that religion. This is something different which immediately your lordships would get. But in any case, this is the argument, not the finding of the court. Reference is made in this connection to clause 2A of Article 25 and clause D of Article 26. We'll take up these points for consideration one after the other. Please note one thing. There were two issues, 26B and 26D. Right to manage the property and right to manage its own affairs, my Lord. Now, kindly, my Lord, come to page 176.
170?
176.
Yes.
Lord, the second unnumbered paragraph. My Lord, SCR doesn't have, unfortunately, para numbers. We now come, your lordship gets one. We now come to Article 25, which, as its language indicates, secure to every person, subject to public order, health, and morality of freedom, not only to entertain such religious belief as may be approved by his judgment and conscience, but also to exhibit his belief in such outward acts as he thinks proper, and to propagate or disseminate his ideas for the edification of others. A question is raised as to whether the word persons here means individuals only or includes corporate body as well. Well, that your lordships can skip and come to the last para. As regards Article 26, the first question is, what is the precise meaning or connotation of the expression religious denomination, and whether a mutt could come within this expression? The word denomination has been defined in Oxford Dictionary to mean a collection of individuals classed together under the same name. This definition is not accepted. So as per Oxford, it should be having the same name. A religious sect or body having a common faith and organization and designed by a distinctive name. Designated by a distinctive name. It is well known that the practice of setting up mutts as centers of theological teachings was started by Sri Shankaracharya and was followed by various teachers since then. After Shankara came a galaxy of religious teachers and philosophers who founded different sects and subsects of the Hindu religion that we find in India as the present day. Each one of such sects or subsects can certainly be called a religious denomination as it is designated by the distinctive name. In many cases, it is the name of the founder and has a common faith and common spiritual organization. My Lord, please pause here for a moment. My Lord, common name may perhaps not be required, my Lord, in my respectful submission. For example, under the fold of Hinduism, my Lord, there can be Shaivites. There is no common designated name of Shaivites, but they are a denomination, and there can be a denominational religious place for Shaivites, subject to, my Lord, of course, entry, etc., my Lord. The followers of Ramanuja, who are known by the name of Sri Vaishnavas, undoubtedly constitute a religious denomination, and so do the followers of Madhavacharya and other religious teachers. It is a fact well established by tradition that the 8 Udupi Mats were founded by Madhavacharya himself, and the trustees and the beneficiaries of the Mats profess to be followers of that teacher. The High Court has found that Mutt in question is in charge of Sivali Brahmins, who constitute a section of followers of Madhavacharya. As Article 26 contemplates, not merely a religious denomination, but also a section thereof, the Mutt or spiritual fraternity represented by it can legitimately come within the purview of this article. The other thing that remains to be considered in regard to Article 26 is what is the scope of Clause B of the article which speaks of management of its own affairs in the matter of religion. The language undoubtedly suggests that there could be other affairs of a religious denomination or a section thereof which are not matters of religion and to which the guarantee given by this clause would not apply. The question is, where is the line to be drawn between what are matters of religion and what are not? It will be seen that besides the right to manage its own affairs in matters of religion, which is given by Clause B, the next 2 clauses of Article 26 guarantee to a religious denomination the right to acquire and own property and to administer such property in accordance with law. The administration of its property by a religious denomination has thus been placed on a different footing from the right to manage its own affairs in the matter of religion. The latter is a fundamental right which no legislature can take away. Latter means B, 26B. Whereas the former can be regulated by laws which the legislature can validly impose. It is clear, therefore, that the questions merely relating to administration of properties belonging to a religious group or institution are not matters of religion to which Clause B of the article applies. Pausing here for a minute, the first part makes 26B absolute, that there can be no law, and that is one way of looking at it, that it is a standalone island provision, and therefore it may not be curtailed either by Lord Part 3, except, my Lord, possibly 25(2)(b) for social reform, my Lord. That is also, my Lord, one of the arguments the other side would be making, my Lord, and my Lord, that is a view, my Lord, which your Lordship will have to take. But otherwise, my Lord, 26B, as per Sirur Mutt, is a standalone provision, cannot be interfered with by operation of law, except that it is secular, etc., my Lord, it is not religious activities. What then are the matters of religion? The word religion has not been defined in the Constitution, and it is a term which is hardly susceptible to any rigid definition. In an American case, it has been said that the term religion has reference to one's views of his relation with his creator and to obligations they impose of reverence for his being and character and the obedience of his will. It is often confounded with cultus of form or worship of a particular sect, but is distinguishable from latter. We do not think that the above definition can be regarded as either precise or adequate. Someone who understands India and the plurality of India, my Lord, could have written this. only could have written this. Articles 25 and 26 of the Constitution are based for the most part upon Article 44(2) of the Constitution of Ayr, and we have great doubt whether definition of religion as given above could have been in minds of our constitution makers when they framed the Constitution. Religion is certainly a matter of faith with individuals or communities, and it is not necessarily theistic. Theistic people believe at least in one God. But in Indian context, you need not believe in God. You might believe in Advaita also. Yes. There are well-known religion in India.
Sorry,
Not correct.
Dvaita and Advaita are different.
There you are not
Advaita
correct.
is Shankaracharya's philosophy.
I'm sorry. I'm sorry. I'm sorry.
The word you want is Gnostic.
Gnostic
Gnostic.
or agnostic.
There is a difference between Gnostic and Advaita.
Yes.
There is.
Advaita,
is a formless God.
Advaita is founded by
Advaita means not two separate. Advaita means I am him and he is me.
Aham Brahmasmi.
Aham Brahmasmi.
That is Adi Shankaracharya, that the God
Brahmasmi.
is within me. Therefore, a man must be reached to the
Spiritual level.
status of, that is what all the philosophers.
There's always a debate
But
between
It is-
Advaita and Advaita.
It is
Always.
Shivoham or Aham Brahmasmi. It is the same thing.
Bhakti, between the man is lower, God is higher, and there is bhakti between the man and the God. That is a relationship. But each one, religion means having a common philosophy which pertains to the relationship of man to God. It can be Shaivism, it can be
Existence
Advaitism,
of God is to be
it
accepted.
can be Jainism, it can be Buddhism, it can be Christianity, or even Islam.
That's what next line says. But interestingly, nothing to do with this matter, Lord, there was a philosopher and a spiritual leader in Islam called Al-Hillaz Mansoor. He said Anal Haq, which is loosely translated to Aham Brahmasmi. But since that was about a different religious text was different.
More elaborately described in Riyalus Salihin, which is the collection of hadiths written by Abu Zakaria Nawawi, which speaks about inner self, realization of self.
Yes.
That is a principle being adopted in South Indian continent, like, in Tamil Nadu more particularly.
Shaivism.
Saivism. That's the concept of self-realization.
Yes, that there is no duality. That's how Lord Adi Shankara also said, there is no duality. You are the Brahma. Brahma is inside you. But that is the next sentence. There are well-known religions in India like Buddhism and Jainism which do not believe in God or in any intelligent first cause. A religion undoubtedly has its basis in a system of beliefs or doctrines which are regarded by those who profess that religion as conducive to their spiritual well-being, but it would not be correct to say that religion is nothing else but a doctrine of or belief. A religion may not only lay down a code of ethical rules for its followers to accept, it might prescribe rituals and observances, ceremonies, and modes of worship which are regarded as integral part of religion. Please mark, not essential part of religion. This is where, my lord, the Dargah committee judgment goes wrong. And I will show, my lord, I'm my lord, convinced that this is not what Sirur Mat means. Integral part of the religion, not essential part of religion. And these...
It is called the Anushtanas with regard to that particular form of philosophy. That cannot be a subject matter of a court's decision. That is what...
I'm grateful. But not the learned judges also.
Let us say even this particular mutt, which is propagating a particular philosophy, Shaivism or Advaitism, the Anushtanas which are followed there, that cannot be a subject matter of a court decision. See, you cannot say why you are following a particular thing.
Whether it is essential in your religion or not can never be the test.
That is the essence of this judgment.
Yes. They say, my lord, what your ladyship described as Anushtana, they say Karma Kanda. My lord, now please further.
Kanda, we have another meaning for that.
Yes, sir. No, my lord, this is,
Will know what it is in Kannada.
no, is it?
Karma Kanda, you say like this, karma. Like a
Anushthanas. My lord, I read from the judgment. My lord, it's not my word, but karma kanda, my lord, is loosely, according to me, Anushthan. My lord, the modes of worship, my lord, ceremonies, rituals. Rituals is something nearer to that. My lord. Modes of which are regarded as integral parts of religion, and these forms and observances might extend even to matters of food and dress. The guarantee under our constitution not only protects the freedom of religious opinion, but it protects also acts done in pursuance of a religion, and this is made clear by the use of the expression practice of religion in Article 25. Latham, Chief Justice of the High Court of Australia, while dealing with the provision of Section 116 of the Australian Constitution, which inter alia forbids the Commonwealth to prohibit the free exercise of religion, made the following weighty observation. Well, see the irony. Chief Justice Latham was a known non-believer. Latham. He was also chairman of Rationalist Association of Australia. But his view of is, and it's a appears to be a comprehensive view. It is sometimes suggested in discussions on the subject of freedom of now, Latham is Chief Justice Latham is being quoted. It is sometimes suggested in discussions on the subject of freedom of religion that though the civil government should not interfere with religious opinions, it nevertheless may deal as it pleases with any acts which are done in pursuance of religious beliefs without infringing the principle of freedom of religion. It appears to me, this is suggestion recorded, now the court's finding. It appears to me to be difficult to maintain this distinction as relevant to the interpretation of Section 116. The section refers in express terms to the exercise of religion, and therefore it is intended to protect from the operation of any Commonwealth laws, acts which are done in exercise of religion. Thus, the section goes far beyond protecting liberty of opinion. It protects also acts done in pursuance of religious belief as a part of rituals or anusthana, as the ladyship said. Then these observations apply fully to the protection of religion as guaranteed by the Indian Constitution. Restrictions by the state upon free exercise of religion are permitted both under Article 25 and 26 on grounds of public order, morality, and health. Clause 2A of Article 25 reserves the right of state to regulate or restrict an economic, financial, political, and other secular activities which may be associated with religious practice, and there is further right given to the state by subclause B, under which the state can legislate for social welfare and reform, even though by so doing it might interfere with religious practices. So there can be a law providing for social reform, even if it interferes with the religious belief, etc., etc. Now, my lord, is the crucial part. And please bear in mind, the court was considering Article 26 small b and Article 26 small d, the right to administer property. And now the court records the learned Attorney General, the then Attorney General's submission. The learned Attorney General lays stress upon clause 2A of the article, and his contention is that all secular activities which may be associated with religion but do not really constitute an essential part of it are amenable to state regulation. This is the contention, that essentiality has to be considered, and if it is not essential, it can be regulated. Now, kindly see how the court deals with. The contention formulated in such broad terms cannot, we think, be supported. In the first place, what constitutes the essential part of religion is primarily to be ascertained with reference to the doctrines of that religion itself. If the tenets of any religious sect of Hindu prescribe that offering of food should be given to the idol at particular hours of the day, that periodical ceremony should be performed in a certain way at certain periods of the year, or that there should be daily recital of sacred texts or oblations to the sacred fire, all these would be regarded as part of religion, and that mere fact that they involve expenditure of money or employment of priests and servants or use of marketable commodities would not make them secular activities partaking of a commercial or economic character. All of them are religious practices and should be regarded as matters of religion within the meaning of Article 26B. What Article 25(2)(a) contemplates is not regulation by the state of religious practices as such. Now, this is the important word. Not religious practices as such, the freedom of which is guaranteed by the Constitution, except when they run counter to public order, health, and morality, but regulation of activities which are economic, commercial, or political in their character, though they are associated with religious practices. We may refer in this connection to a few American and Australian cases, all of which arose out of activities of persons connected with the religious association known as Jehovah's Witnesses. This association of persons loosely organized through Australia, USA, and other countries regard the literal interpretation, the originalist approach, my lord, the literal interpretation of the Bible as fundamental to proper religious beliefs. This belief in the supreme authority of the Bible colors many of their political ideas. This is, my lord, the issue arose because of the political ideas which were colored by the religious doctrines. They refused to take oath of allegiance to the king or other constituted human authority, and even to show respect to the national flag. And they decry all wars between nations and all kinds of war activities. In 1941, a company of Jehovah's Witnesses incorporated in Australia commenced proclaiming and teaching matters which were prejudicial to war activities and the defense of Commonwealth, and steps were taken against them under the national security regulations of the state. The legality of the action of the government was questioned by means of a writ petition before the High Court, and the High Court held that the action of the government was justified, and Section 116, which guaranteed freedom of religion under Australian Constitution, was not in any way infringed by national security regulations. These were undoubtedly political activities, though arising so and so, so and so. Now, my lords, may kindly directly come to 183. Now, my lord, American and Australian cases are, my lord, referred to and distinguished. Your lordships are aware, the Bill of Rights, my lord, in America, the upper equivalent to fundamental rights, the First Amendment, Second Amendments, etc., they are in absolute terms. We have our own tailored fundamental rights, my lord, with sometimes limitations, sometimes, my lord, some restrictions permissible, etc. My lord, 183, second para. It is to be noted that both in American as well as in Australian constitutions, the right to freedom of religion has been declared in unrestricted terms without any limitation whatsoever. Limitations, therefore, have been introduced by the courts of law in these countries on the ground of morality, order, and social protection. An adjustment of the competing demands of the interest of government and the constitutional liberties is always a delicate and difficult task, and that is why we find difference of judicial opinion to such an extent in cases decided by the American courts where question of religious freedoms were involved. Our constitution makers, however, have embodied the limitations which have been evolved by judicial pronouncements in America or Australia in the constitution itself, and language of Article 25 and 26 is sufficiently clear to enable us to determine without the aid of foreign authorities as to what matters come within the purview of religion and what do not. My lord, there was no reverence to foreign authorities, my lord, in those days. As we have already indicated, freedom of religion in our constitution is not confined to religious beliefs only. It extends to religious practices as well, subject to the restrictions which the constitution itself has laid down. Under Article 26B, therefore, a religious denomination or organization enjoys complete autonomy in the matters of deciding as to what rites and ceremonies are essential according to the tenets of the religion they hold, and no outside authority has any jurisdiction to interfere with their decision in such matter. What is essential is for the denomination to decide. Kindly see, this is 7-judge bench, which is deviated from, my lord, in Dargah committee. I'll show. Of course, the scale of expenses to be incurred in connection with administration of property belonging to the religious denomination and can be controlled by secular authorities in accordance with any law laid down by a competent legislature. For it could not be the injunction of any religion to destroy the institution and its endowment by incurring wasteful expenditure on rites and ceremonies. It should be noticed, however, that under Article 26D, it is fundamental rights of a religious denomination or its representative to administer its properties in accordance with law. And the law, therefore, must leave the right of administration to the religious denomination itself, subject to such restrictions and regulations as it might choose to impose. My lord, this is 26D, which is subject to law, because textually it is so. A law which takes away the right of administration from the hands of a religious denomination altogether and vests it in any other authority would amount to a violation of the right guaranteed under Clause D of Article 26. My lord, thereafter, your lordships may, my lord, kindly come to. My lord, thereafter, the Honorable Court goes into each provision of the Act under challenge and either, my lord, declares it void or does not declare it void. My lord, I have an issue, my lord, but it's a small issue, my lord. It's regarding dictum. Dictum, my lord. Dictum is, my lord,
Section 54 and 55.
it was section 54 and 55. My lord, I may not trouble your lordships much, but, my lord, dictum is, my lord, what would I use for the purpose of offering prayers to the deity, my lords? My lord, that court says that is a secular activity and that can be decided that don't use, say, chandan, but use something else, etc. My lord, which according to me is purely only a religious activity. Unless it is so wasteful that I buy, say, 10 kilos of gold, then it may be difficult, my lord. But page 189 is page 54, my lord. It is, but I'll not, my lord, trouble your lordships with that. Now come to, my lord, page 202. Page 202, Ratilal Panachand Gandhi versus State of Bombay and another. My lord, this is again, please see the call, my lord, the bench composition, the same. Out of 7 in Sirurmat, 5 honorable judges, but Chief Justice M.G. Mahajan, Mukherjee, Justice B.K. Mukherjee, Justice S.R. Das, Justice Vivian Bose, and Justice Ghulam Hussain. And 203, your lordships would find, it is 2 days after, that is 18th of March, 1954. My lord, according to me, my lord, it takes the same view, and obviously, my lord, the same learned judge was the author, my lord, and it, my lord, takes the same view, and therefore, my lord, I may not bother your lordships, my lord, with this. Kindly now come to, my lord, the third judgment, which I'll read from here, and thereafter I'll read only excerpts for rest of the judgment. And that is, my lord, very important judgment, my lord, Devaru. My lord, it is Venkatarama Devaru and others versus State of Mysore and others. My lord, this is possibly page 224. 225, sorry, 225.
Devaru, 5 judge.
Five honorable, yes. Devaru is a 5 honorable judge.
Judgment 7 judge.
Shirur Math is 7, Ratilal Gandhi is 5, Devaru is 5.
All are 5, nobody is close.
Venkaramana is also 5 judges.
Yes, Ratilal is also 5 or 5 honorable judges. The same, incidentally, my lord, I am saying in the same composition because I don't have to read. Same composition and the same learned judge has authored the judgment. 2 days pronounced after 2 days.
Yes, that was a problem.
Lord, this
Judgment is by Justice Venkatrama Iyer.
yes.
Post is there in there. Post is on the Sarkar has come.
It's on strict.
Post was also.
Lord, this judgment in my reading and subject to what finally the way your lordship reads is possibly the first judgment and the only judgment which decides how to read 25 and 26 together.
Excommunication case also does it.
Now, this is the first in point of time. There is, my lord, Saidana case, my lord, that excommunication case deals with, my lord, but I'll not go into it because facts we are not going into, my lord. This was, my lord, kindly see page 227. What was under challenge? Substantial question of law. Your lordship gets, my lord. The substantial question of law which arises for decision in this appeal is whether the right of a religious denomination to manage its own affairs in matters of religion guaranteed under Article 26B is subject to and can be controlled by a law protected by Article 25(2)B, throwing open a Hindu public to all cases and sections of the Hindus. This was the question, my lord. Finally, my lord, see what was the section which was validity of which was under challenge, my lord, is at page 229. In Devaru judgment, my lord, this was under challenge, section 3(1) of the Impugned Act, which is at page 229. Your lordship gets, my lord, the Chief Justice gets. 229. Notwithstanding any law, custom, or usage to the contrary, persons belonging to the excluded classes shall be entitled to enter any Hindu temple and offer worship therein in the same manner and to the same extent as Hindus in general, and no member of any excluded class shall, by reason only of such entry or worship, whether before or after the commencement of this act, be deemed to have committed any actionable wrong or offense, or be sued or prosecuted therefore. My lord, this was entry of, my lord, scheduled caste persons, my lord, in the temple. Now, please see, my lord, page 230.
Very similar
Madras
to
Temple
section
Entry
3 of
Authorization
the
Act.
Kerala.
Yes.
Very similar to section 3 of the Kerala.
Kerala came 65, this is 47 Madras.
1947.
That, my lord, I'll come to, my lord. I'm not touching the Sabarimala part because I will deal with in a different manner as a sui generis case. Right now, when your lordships are examining questions of law and the judicial policy which your lordships would apply henceforth, my lord, it may be, my lord, advisable for me not to be colored by one particular sui generis case, my lord. Though it is my case that it is wrongly decided, deserves to be, my lord, declared a wrong law for more than one reasons, my lord. But I leave it at that for the time being, my lord. Please come to page 230. The second part. On January 26, 1950, the Constitution came into force, and therefore, thereafter, on February 11, 1950, the plaintiffs raised the further contention by way of amendment of the plaint that in any event, as the temple was a denominational one, they were entitled to the protection of Article 26, that it was a matter of religion as to who were entitled to take part in worship in a temple, and that Section 3 of the Act, insofar as it provided for the institution being thrown open to communities other than Gauda Saraswat Brahmins, was repugnant to Article 26B of the Constitution. on these pleadings, the parties went to trial. Now, this was a case arising from the civil suit. Please mark, my lord, not at 226 or 32, where affidavits decides, my lord, questions of faith and belief. Now, kindly see, my lord.
The suit was filed. Article 226 had not yet come on the statute book.
Yes, 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 yes.
During the pendency of the suit,
Even
constitution was enforced.
Lord, suit was filed before constitution came into.
Yes.
I'm not saying that. I'm saying, my lord, that this was a case where there was a factual adjudication. My lord, some fifth line from the top, my lord. I'll read. On these pleadings, the parties went to trial. The subordinate judge of South Kanara, who tried the suit, held that though the temple had been originally founded for the benefit of certain immigrant families of Gowda Saraswat Brahmins, in course of time it came to be resorted to by all classes of Hindus for worship, and that accordingly it must be held to be.
Suit was of 1915.
Yes, yes. No, that's not the argument. I'm just factually saying.
We are just saying historically.
Yeah.
Therefore, they amended the pleading after the constitution came in.
Yes. Yes. Yes.
There was no article.
Then they raised 26T, etc. My lord, by way of an amendment. Correct.
Yes.
Dealing with the contention that plaintiffs had the right under Article 26B to exclude all persons other than Gowda Saraswat Brahmins from worshipping in the temple, he held that matters of religion in that article had reference to religious beliefs and doctrines and did not include rituals and ceremonies, and that in any event, Article 17 and 25 too, which had been enacted on grounds of high policy, must prevail. No, they relied upon, and rightly relied upon, Article 17. Please come to 232, my lord, somewhere in the bottom. To resume the history of the present litigation subsequent to the dismissal of civil appeal by so-and-so, AS number so-and-so was taken up for hearing, and on the application of the appellants, the proceedings in the writ petition were admitted as additional evidence. On a review of the entire material on record, including those relating to proceedings of writ petition, the learned judges held it established that Sri Ramana Temple was founded for the benefit of Gowda Saraswat Brahmin community, and that it was therefore the denominational one. Then, dealing with the contention that Section 3 of the Act was in contravention of Article 26B, they held that as a denominational institution would also be a public institution, Article 25(2)B applied, and that thereunder all classes of Hindus were entitled to enter into the temple for worship. But they also held that the evidence established that there were certain religious ceremonies and occasions during which Gowda Saraswat Brahmins alone were entitled to participate, and that the right was protected by Article 26B. They accordingly reserved the rights of appellants to exclude all members of public during those ceremonies and on those occasions, and these were specified in the decree. Now, my lords, may kindly see the questions are framed at page 234, and the questions are almost, my lord, similar to, my lord, the cases which your lordships are, to the questions your lordships are answering. Question number 2 at page 234. If it is, first, my lord, is the Sri Venkatramana Temple at Mulki a temple as defined under 2.2? If it is it a denominational temple? If it is a denominational temple, are the plaintiffs entitled to exclude all Hindus other than Gowda Saraswat Brahmins from entering into it for worship on the ground that it is a matter of religion within the protection of Article 26B of the Constitution? If so, is Section 3 of the Act valid on the ground that it is a law protected by Article 25(2)B, that is for reform, etc., and that such a law prevails against the right conferred by Article 26B, and, my lord, it is not thereafter relevant, my lords. Please have a look, my lord, now at the findings. Page 235 at the bottom, Mr. Nambiar, my lord, at the my lord, last fifth or sixth line from the bottom, he contended on the basis of these documents. Your lordship gets, my lord? I'm skipping what is not relevant for the present. And other evidences in the case that whether the temple was a private or public institution was purely a matter of legal inference to be drawn from the above materials, and that notwithstanding that the point was not taken in pleadings, it could be allowed to be raised as a pure question of law. We are unable to agree with this submission, the object of requiring a party to put forward, etc., then kindly see para 2. The next question is whether the suit temple is a denominational institution. Both the courts below have concurrently held that at the inception, the temple was founded for the benefit of Gauda Saraswat Brahmins, but the subordinate judge held that as in course of time, public endowments came to be made to the temple and all classes of Hindus were taking part freely in worship therein. It might be presumed that they did so as a matter of right, and that therefore the temple must be held to have become dedicated to Hindu public generally. So they rejected the argument of a private temple, that it's a public religious institution. The learned judges of the High Court, however, came to a different conclusion. They followed the decision of so-and-so and held that the temple was a denominational one. The learned Solicitor General attacks the correctness of this finding on two grounds. He firstly contends that even though the temple might have been dedicated to the Gauda Saraswat Brahmins, that would make it only a communal and not a denominational institution unless it was established that there were religious tenets and practices special to the community, and that had not been done. Now kindly, my lord, come to the next page, 237. Lord, some 7th or 8th line from the bottom, the law on the subject, my lords. Your lordship gets one. 237, 7th or 8th, 9th line from the bottom. The law on the subject is well settled. When there is a question as to the nature and extent of a dedication of a temple, that has to be determined on the terms of the deed of endowment, if that is available, and where it is not, on other materials legally admissible, and proof of long and uninterrupted usure would be cogent evidence of the terms thereof. Where, therefore, the original deed of endowment is not available, and it is found that all persons are freely worshipping in the temple without, let alone hindrance, it would be proper inference to make they do not do so as a matter of right, and that the original foundation was for their benefit as well. But where it is proved by production of deed of endowment, etc., my lord, I can skip that. Then your lordships may kindly come to 3. On the finding that Sri Venkatramana Temple at Mulki is a denominational institution founded for the benefit of the Gauda Saraswat Brahmins, the question arises whether the appellants are entitled to exclude other communities from entering into it for worship on the ground that it is a matter of religion within the protection of Article 26B. It is argued by the learned Solicitor General that exclusion of persons from entering into a temple cannot ipso facto be regarded as a matter of religion, that whether it is so must depend on the tenets of the particular religion which the institution in question represents, and that there was no such proof in the present case. Now, the precise connotation of the expression matter of religion came up for consideration by this court in Sirurmat, and it was held therein that it embraced not merely matters of doctrine and belief pertaining to the religion, but also the practice of it, or to put it in terms of Hindu theology, not merely its gnana, but also is bhakti and karma kandas. So this is what I was indicating, my lord. The following observations of Justice Mukherjee are particularly apposite. But I'll skip that, I have already read. It being thus settled that matters of religion in Article 26B include even practices which are regarded by the community as part of its religion, We have now to consider whether exclusion of a person from entering into a temple for worship is a matter of religion according to Hindu ceremonial law. There has been difference of opinion, my lord, that can be, my lord, skipped. Your lordships, my lord, directly come to page 242. Para 4. Para 4, your lordship gets. That brings us on the main question for determination in this appeal. Your lordship gets, now this is, my lord, according to me, the important finding starts. Whether the right guaranteed under Article 26B is subject to a law protected by Article 25(2)(b, throwing the suit temple open to all classes and sections of Hindus. Well, first of all, the court was not dealing with the first part of 25(2)(b, namely social welfare and reform. But the logic would apply, my lord. The same logic will have to apply. We must now examine closely the terms of the two articles, Article 25 omitting what is not material. My lord, thereafter they have quoted, my lord, their lordships have quoted. Last line, we have held that matters of religion in Article 26B include the right to exclude persons who are not entitled to participate in the worship according to the tenets of the institution. Under this article, therefore, the appellants would be entitled to exclude all persons other than Gauda Saraswat Brahmins from entering into the temple for worship. Article 25(2)(b) enacts that a law throwing open public temples to all classes of Hindus is valid. The word public includes in its ordinary acceptation any section of the public, and the suit temple would be public institution within Article 25(2)(b, and Section 3 of the Act would therefore be within its protection. The court reads 26(b) in line or in tune or in harmonious way with 25(2)(b. Thus, the two articles appear to be apparently in conflict. Mr. M.K. Nambiar contends that this conflict could be avoided if the expression religious institutions of a public character is understood as meaning institutions dedicated to the Hindu community in general, though some sections thereof might be excluded by custom from entering into them, and that in that view, denominational institutions founded for the benefit of a section of Hindus would fall outside the purview of Article 25(2)(b as not being dedicated for the Hindu community in general. He sought support for this contention in the law relating to entry of excluded classes into Hindu temples and in the history of legislation with reference thereto in Madras. According to Agamas, my lord, I have shown at the outset, my lord, Agamas are one of the last in the line of, my lord, Vedas, Vedangas, etc., etc. My lord, the court considered Agamas a public temple endures where it is not proved to have been founded for the benefit of any particular community, for the benefit of all Hindus, including the excluded classes. But the extent to which a person might participate in the worship therein would vary with the community in which he was born. In so-and-so versus so-and-so, the following statement of law was quoted by the learned judges. Your lordships can skip that. But now directly come to page 245, the second unnumbered para. Now the contention of Mr. Nambiar is that Article 25(2)(b must be interpreted in the background of the law as laid down in Gopal Mupnar versus so-and-so, and the definition of temple given in the statutes mentioned above, and that the expression religious institutions of a public character must be interpreted as meaning institutions which are dedicated for worship to the Hindu community in general, though certain sections thereof were prohibited by custom from entering into them, and that in that view denominational temples will fall outside Article 25(2)(b. My lord, this is the distinction between public character and denominational temple, which, my lord, perhaps, my lord, may not arise in the questions which are referred, my lord, but I'm reading it further. There is considerable force in this argument. One of the problems which had been exercising the minds of the Hindu social reformers during the period preceding the constitution was the existence in their midst of communities which were classed as untouchables, a custom which denied to large sections of Hindus the right to use public roads and institutions to which all other Hindus had a right to access purely on the grounds of birth could not be considered reasonable and defended on any sound democratic principle, and efforts were being made to secure its obligation by legislation. This culminated in enactment of Article 17 as follows. My lord, this justifies my contention that all sections of Hindus is necessarily referable to this caste discrimination which was being taken care of by the founding fathers and mothers of the Constitution. Construing Article 25(2)(b) in light of Article 17, it is arguable that its object was only to permit entry of excluded classes into temples which were open to all classes of Hindus, and that would exclude its application to denominational temples. Now, denominational temples are founded ex hypothesi for the benefit of particular sections of Hindus. My lord, your lordships can, my lord, thereafter consider skipping it, and please come to 246 bottom para. Before that, my lord, something above. My lord, let me complete this. I think otherwise para 2 would be difficult, my lord, to yes, divest trust funds for the benefit of persons who are not beneficiaries under the endowment. He would be committing a breach of trust, and though a provision of the Constitution is not open to attack on the ground that it authorizes such an act, is it to be lightly inferred that Article 25(2)(b) validates what would, but for it, be breach of trust, and for no obvious reason of policy, as in case of Article 17? There is, it should be noted, a fundamental distinction between excluding persons from temples open for purpose of worship to Hindu temples in general, and on the ground that they belong to excluded communities, and excluding persons from denominational temples on the ground that they are not objects within the benefit of the foundation. The former will be hit by Article 17 and the latter protected by Article 26, and it is the contention of the appellants that Article 25(2)(b) should not be interpreted as applicable to both these categories, and that it should be limited to the former. The argument was also advanced as further supporting this view that while Article 26 protects denominational institutions of not merely Hindus, but all communities such as Muslims and Christians, Article 25(2)(b) is limited in its operation to Hindu temples. Well, the second part, obviously second part is under consideration, not social welfare and reform. That is, Lord, religious neutral or throwing open. My lord, this is being discussed. And that it could not have been intended that there should be imported into Article 26(b) a limitation which would apply to institutions of one community and not of others. Article 26, it was contended, should therefore be construed as falling wholly outside Article 25(2)(b), which should be limited to institutions other than denominational ones. The answer to this contention is that it is impossible to read any such limitation into the language of Article 25(2)(b). It applies in terms to all religious institutions of a public character without qualification or reserve. As already stated, public institutions would mean not merely temples dedicated to the public as a whole, but also those founded for the benefit of sections thereof, and denominational temples would be comprised therein. The language of the article being plain and unambiguous, it is not open to us to read into it limitations which are not there, based on a priori reasoning as to the probable intention of legislature. Such intention can be gathered only from the words actually used in the statute, and in a court of law, what is unexpressed has the same value as what is unintended. We must therefore hold that denominational institutions are within Article 25(2)(b). So first ground, my lord, is traversed by this judgment. It is then said that if the expression religious institutions of a public character in Article 25(2)(b) is to be interpreted as including denominational institutions, it would clearly be in conflict with Article 26(b). Lord, please remember 26 is an article conferring fundamental rights on denominations. So they say, they test the argument, learned judges, that if 25(2)(b) is also made applicable to denominations, how will you reconcile it with 26(b) rights of a denomination? In conflict with Article 26(b). And it is argued that in that situation, Article 26(b) must, on its true construction, be held to override Article 25(2)(b). Three grounds were urged in support of this contention, and they may now be examined. The first, it was firstly argued that while Article 25 was stated to be subject to other provisions of this part, there was no such limitation on the operation of Article 26, and that, therefore, Article 26(b) must be held to prevail over Article 25(2)(b). So textual interpretation, that textually one limitation made by the same draft person, my lord, in 25 is not incorporated in 26, and therefore it should be presumed that they never intended it to be governed by the part 3. But it has to be noticed that the limitation subject to other provisions of this part occurs only in clause 1 of Article 25 and not in clause 2. My lord, this I have some issue, my lord, as a proposition of law. It can never be said that Article 25(2) is also unbridled and it's not supported by other provisions of the Fundamental Rights chapter, but be that as it may. Clause 1 declares the rights of all persons to freedom of conscience and right freely to profess, practice, and propagate religion. It is this right that is subject to other provisions in the Fundamental Rights chapter. One of the provisions to which the right declared in Article 25(1) is subject is Article 25(2). So since 25(1) says all provisions of this chapter, even this article is also included in the chapter. So 25(2)(b) will control 25(1). A law, therefore, which falls within Article 25(2)(b) will control the right conferred by Article 25(1), and the limitation in Article 25(1) does not apply to that law. It is next contended that while the right conferred under Article 26(d) is subject to any law which may be passed with reference thereto, there is no such restriction on the right conferred by Article 26(b). It is accordingly argued that any law which infringes the right under Article 26(b) is invalid, and that Section 3 must accordingly be held to have become void. Reliance is placed on the observations in Shirur Math. The result then is that there are, now this is important, my lord.
One thing, Mr. Solicitor, in Article 25(1), it says other provisions of this part. Other provisions can
May not include 2.
Article 25 itself.
So it may not include 2.
Subject to Article Clause 2, it would have been written.
Therefore, my lord,
Other provisions will not include 25.
Correct. And therefore not include 25(2).
Correct.
The result then is that there are 2 provisions of equal authority, neither of them being subject to the other. Now, this is the problem, real problem, my lord, which presently, my lord, we are facing. The question is how the apparent conflict between them is to be resolved. The rule of construction is well settled that when there are in an enactment 2 provisions which cannot be reconciled with each other, they should be so interpreted that if possible, effect could be given to both. This is what is known as the rule of harmonious construction. Applying this rule, if the contention of the appellant is to be accepted, then Article 25(2)(b) will become wholly nugatory in its application to denominational temples, though, as stated above, the language of that article includes them. On the other hand, if the contention of the respondents is accepted, then full effect can be given to Article 26(b) in all matters of religion, subject only to this, that as regards one aspect of them, that is entry into temples for worship, the rights declared under 25(2)(b) will prevail, while in the former case, Article 25(2)(b) will be put wholly out of operation. In the later effect, a later effect can be given to both that provision and Article 26(b). We must accordingly hold that Article 26(b) must be read subject to Article 25(2)(b). My Lord, it is for your lordships to decide, my lord, whether they did so because of the issue involved, my lord, namely some class being excluded. That was a real problem. The law tried to, my lord, bring in a reformative law, my lord, provision in terms of Section 3, or as a proposition of law, the court said, my lord, according to me, it is a proposition of law which is settled that 26 will have to be read in conformity with and not in conflict with Article 25(2)(b). It remains to deal with the...
Just a minute. Right to entry into a temple for worship, is it to be fine-tuned with right to enter per se?
No,
right to enter only entry to a temple and right to entry for worship.
There are separate rights. These are separate rights. But in facts of this case, since the contention of the temple was that...
The devotee is there, he goes there only for darshan, not for worship. Right to worship is taking part in the ritual, or it is a composite?
That is recognized. The judgment further, my lord, recognizes them. But let me tell your lordships, both are different rights. Right to enter for worshipping, but right to enter for darshan is different. Right to enter for worshipping, that is conducting rituals, is different. Here was a case where the concerned denominational temple said that the statutory provision which permits Dalits to enter the temple is bad.
Only for entry, that is...
Yes, ma'am, and therefore I'm putting it very simply, without, my lord, any verbal gymnastics. This is what, my lord, the contention was, and this is how it was rejected. Their argument was that right to restrict them from entering is my 26(b) rights. And other side said, no, the law is traceable under 25(2)(b). It's a reform law. And therefore, court says we will have to reconcile both.
Put it in the lighter vein. Probably the bench could have decided what do they mean by public character. That could have really resolved it instead of trying to reconcile, do this and that.
Lord, if your lordships come to, my lord, the judgment which they rely upon, my lord, Gopala Mupana...
Activity comes under the public character, then automatically 25 to be...
Correct. My lord, would your lordships come to page 245 to answer my lord Justice Sundaresh's query? 245.
Public character. Then it will come.
But there is a judgment which this bench, my lord, refers to, Gopala Mupnar versus Subramania Iyer.
Yes.
This is the judgment of Privy Council which exactly does what your lordships are right now indicating. And that could have been an option.
That could have been the proper option.
Yes.
Instead of trying to figure out something which is not there.
I'm sorry, it's Madras High Court, not Privy Council.
Mr. Solicitor, we would like you to enlighten us on this because we just placed Devaru. Devaru holds subsection 1, subclause 1 of Article 25 makes it subject to other provisions of this part, thereby Article 26. But subclause 2 does not have this subjecting clause or subordination clause. But if you see subsection 2, it is only an enabling provision. It's an enabling provision to make statutory enactments. And we all know that in the idea of groom norm, that the constitutional fundamental right provision has a higher prerogative than a statutory enactment.
Correct.
Yes.
Now, if you see clause 2 from that perspective, the non-obstantive word is nothing in this article. This article is Article 25 and not 26.
Correct.
And in that situation, Mr. Solicitor, we would like you to enlighten us whether a law made in the enabling scope of clause 2
B.
would not be tested on the anvil of 26, a fundamental right. This has not been considered in Devaru.
No, it is. It is. But let me complete. It is.
To add it to this,
Mr. Solicitor, I
observation,
may be wrongly reading Devaru. Please place.
No, maybe I am wrong, my lord, but let me see the way I read it. my lord.
the other observation is clause 2 of Article 25 is in two parts. One is to preserve what exists. What exists is existing law, which can also include a custom or an usage.
Your ladyship is reading where? my lord?
25(2) is in two parts.
Hmm.
The first part with the non-obstante clause is to preserve the operation of any existing law, which can include even a custom or a usage, because that is law. The second part is, or nothing in this article will prevent the state from making any law, as my learned brother Justice Bhakti said, that is enabling the state to make a law for social reform.
No, my lord,
The first part of Article 25.
kindly read, would the Honorable Court read A, 25 2A?
No, no. 25
Nothing in
article.
this article shall affect the operation of any existing law,
That is the first part.
first part, or
Or,
prevent the state from making any law.
so the second part is enabling the state.
Preserving
First
is for.
part, the Constitution preserves the existing law, which
Correct.
can include even a custom or a usage.
No, my lord, no.
Although,
Your ladyship is on Article 13.
although existing law is defined under Article 36, Article 366, it is defined under Article 366, correct?
My lord, for this part it is 13, but we may not travel that, my lord.
13 and 366 also could be reconciled. There is a definition of existing law under Article 366.
The definition clause.
And existing law can also be read as custom or usage which comes within the scope of law under Article 13. So we are saying this subclause 2 of Article 25 is in two separate parts. One is a preservation of what was.
No, there is enabling.
The other is enabling.
Correct, my lord. There is no issue on that, my lord. Preservation, my lord, but what will be preserved or what is enabled is A and B. Please see, my lord, what is to be preserved? Regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. If existing before the Constitution would be preserved, if not existing, it would not prevent the Parliament or the legislature, as the case may be, from making any law, but without touching the religious practice, those activities which are associated with religious practice, but are purely in the nature of economic, financial, political, or other secular activities.
Enabling the state to do it in future.
Correct.
Future.
Correct, correct.
That is.
But it can even be amendment of the. It can even be amendment.
By an enactment or whatever way it has to do.
It has to be by enactment.
But what existed on the day the Constitution came into force?
We are not at odds. Your ladyship is right, my lord. That is, if it is an activity which existed, which is economic, financial, political, or secular.
Existing law.
No, existing law only with respect to economic, financial.
Yes, my lord.
Political or secular.
Yes, my lord. There is no dispute on that.
Or is only for present and future, but the field of interference is clearly indicated.
No, my lord. May I know for what, my lord, we are doing this exercise? My lord, to answer what?
No, better. Do you want to read anything further in this judgment? I think what relevant part has been.
Yes, no, my lord. I'm reading only 2 pages now. There are only 2 pages, my lord. Kindly see. 249, the learned solicitor.
Really laboring hard only for reconciliation between two provisions, 25 and 26. We understand that part.
No, the way, my lord, Devaru has tried hard, my lord. I am only showing. My lord, page 249. The learned Solicitor General for the respondents assails this position of the decree on two grounds. He firstly contends, my lord, your lordships can skip, but we agree with that right protected by my lord, let me read fully, my lord, sorry. He firstly contends that the right to enter into a temple which is protected by Article 25(2)(b) is a right to enter into it for purposes of worship, that right should be liberally construed, and that the modification in the question constitute a serious invasion of that right and should be set aside as unconstitutional. We agree that the right protected by Article 25(2)(b) is a right to enter into a temple for the purposes of worship, and that further it should be construed liberally in favor of the public. But it does not follow from this that right is absolute and unlimited in character. No member of Hindu public could, for example, claim as a part of right protected under Article 25(2)(b) that a temple must be kept open for worship at all hours of the day and night, or that he should personally perform those services which the archakas alone could perform. It is again a well-known practice of religious institutions of all denominations to limit some of its services to persons who have been specially initiated, though at other times the public in general are free to participate in the worship. Thus, the right recognized by Article 25(2)(b) must necessarily be subject to some limitations or regulations, and one such limitation or regulation must arise in the process of harmonizing the right conferred by Article 25(2)(b) with that protected by Article 26(b). So again, my lord, they harmonize it. That's all, my lord, I can say. Now come, my lord, last, my lord, last 4 lines. But where this line is important. See, it's not a right. Enabling provisions. We have. Last paragraph, my lord. We have held, page 249, we have held that the right of a denomination to wholly exclude members of the public from worshipping in the temple, though comprised in Article 26(b), must yield to the overriding right declared by Article 25(2)(b) in favor of the public to enter into a temple for worship. But where the right claimed is not one of general and total exclusion of public from worship in the temple at all times, but exclusion from certain religious services, they being limited by the rules of the foundation to the members of the denomination, then question is not whether Article 25(2)(b) overrides that right so as to extinguish it, but whether it is possible so to regulate the rights of persons protected by Article 25(2)(b) as to give effect to both the rights. If the denominational rights are such that to give effect to them would substantially reduce the right now proportionality. My lord, kindly see applying proportionality without, my lord, any high-sounding words. If the denominational rights are such that to give effect to them would substantially reduce the rights conferred by Article 25(2)(b), then of course, on our conclusion that Article 25(2)(b) prevails as against Article 26(b), the denominational right must vanish. But where there is not the position, and after giving effect to the rights of the denomination, what is left to the public of the right of worship is something substantial and not merely the husk of it. There is no reason why we should not construe Article 25(2)(b) as to give effect to Article 26(b), and recognize the rights of the denomination in respect of matters which are strictly denominational, leaving the rights of the public in other respects unaffected. The question then is one of fact as to whether the rights claimed by the appellants are strictly denominational in character, and whether, after giving effect to them, what is left to the public of the right of worship is substantial. So apply, my lord, not in so many words, proportionality doctrine. That proportionality, if requires 26B to be given precedence or prominence, give 26B the precedence or prominence. If the effect of 25 2B is almost nullifying 26B, don't give effect to 25. That's, my lord, how I understand, my lord, this judgment.
Harmonious construction.
Harmonious construction, no article is subordinate, no article is subservient, and therefore the lordship say that read both together, consider facts of each case, and if you find that giving effect to one is almost nullifying the second, then don't give effect to one. Therefore, my lord, the key word would be 25B is an enabling provision and not a fundamental right. 25(2)B is not a fundamental right of anyone. It enables to curtail fundamental rights.
In some way, perhaps I reframe the question. Any legislation to achieve the purpose of 25B may have a constitutional import, like the Right to Information Act, which is a statutory enactment giving expression to 1918. So any right to entry to temple legislations like the Madras or any other legislations
Lordships are right.
will be giving the constitutional expression to 25B to objects. So the objects of the constitution are articulated.
The social welfare and reform, for example.
Yes.
This would,
We have to examine it from
your lordship's example is, my lord, reform.
So yeah, have a very common similar example of the statutory act, like the Right to Information Act, a statutory legislation which articulates the fundamental right to speech, expression, and information. Similarly, any Right to Temple Act has to be seen from the anvil of Article 20, Clause 2B, having a constitutional import.
Otherwise, my lord,
enforcing 2B rights.
Otherwise, my lord, my worry is this, my lord, if we read 26,
Mr. Solicitor, followed you. We followed your submission.
that if we read it in isolation, then something horribly wrong, my lord, something which shakes your lordship's conscience, or something shakes the conscience of the legislature. Legislature reflects ultimately people's will. That this cannot be permitted in a denomination. And therefore, we must come out with a law. Then, my lord, 26B making it absolute, Lord, would thwart reformative actions also. But it should, Lord, therefore, my lord, weighing, my lord, which one is dominant, which one is prominent.
Species of argument which we are presently articulating was not advanced in Devadu.
It was not. I bow.
Legislation like right to enter a temple is a statutory instrument, and in view of the non-obstante expression restricting it to Article 25, whether 26 can be a touchstone of its constitution. That issue was not really raised or decided.
Yes, now I come to Dargah Committee. Now I'll move fast, my lord, because these were the three judgments I wanted to read. The Dargah Committee takes a departure, and in my respectful submission, contrary to what is laid down in 7-judge judgment of Serur Mutt, and says that essential religious practice is the test. So the court would decide that not only this practice is religious practice, whether it is essential for that religion or not. Which, in my respectful submission, my lord, a wrong insertion by judicial interpretation, not coming out either from the text of 25 or 26, nor coming out from Shirur Mutt, which is 6 to rely. Lord, may I start today or tomorrow? This would be a new point.
So actually, this judgment in Venkatramana Devaru, there can be a possibility of 26B prevailing over 25.
In facts, yes. In facts of the case, your ladyship is right.
There can be.
Absolute.
Yes.
Absolute. Absolute. Absolute.
I didn't say that.
No, my lord. My lord, what I said was, your ladyship,
We inferred it.
No, my lord.
So our inference is correct.
My lord, that is the difference between, my lord, the intellectual level of a judge and a lawyer, my lord. But what I said was that you will have to decide on facts whether 25(2)(a) is prominent, what is the object, or 26(b) right is prominent on facts of each case. But your ladyship's articulation was better, my lord. I respectfully, my lord, agree.
Your Lord, just a small request, Your Lordships, the transcripts which are available, if Your Lordships could direct that to be shared with the councils, it will assist all of us to avoid repetition, Your Lordships. The transcripts which are of the hearing, if Your Lordships could make it available to the councils, it will help us in avoiding repetition so that Your Lordships are best.
Just come.
We'll make it available. Great.